Good morning. This is the New York City Board of Standards and Appeals for November 18, 2014. We'll begin with a special order calendar, decision items. Item number 1, 72456BZ, 4242 Francis Lewis Boulevard, Queens.
Hello, good morning, Eric Palatnik.
Hi, good morning. Before we start, I just wanted to welcome a new member of our team. This is our Deputy General Counsel, David Schnackenberg, who just joined us. We're very happy to have him. So for a motion to grant on this?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you and welcome.
Item number 2, 162 and 163, 95BZ, 3060, 3074 Westchester Avenue, the Bronx.
No one's here on this item? Okay. For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Item number 3, 17803BZ, 11402 Van Wyck Expressway, Queens.
Hello, good morning again, Eric Palatnik.
For a motion to grant, but on condition of changing the slats in the fence?
Oh, Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
And Commissioner Otley Brown?
Aye.
Thank you.
Item number 4, 4208BZ, 182 Girard Street, Brooklyn.
Okay, with this one, oh, did you want to introduce yourself?
I'm not sure if you need to reopen the hearing on it or not.
Right.
You're going to discuss it and need to reopen.
Yes, so we may need to defer decision on this until we do need to defer decision until we hear from DOB about the floodplain regulations.
Okay, and we have a reconsideration submitted to the Department of Buildings on that exact issue. Unfortunately, I had spoken with your board's attorney yesterday, Mr. Bean. They're a little behind the Department of Buildings, unfortunately, by 4 to 6 months on reconsiderations. It would be very helpful if the board, if I know that you have an interest in this, if you could maybe see if there's a way they could, maybe I'll forward to you that application. Of course, I'll follow up with the Brooklyn office, Department of Buildings as well, but I'm often, retorted with the same line that we just have to wait. Hopefully it won't take that long here. It's been in for 2 months already, but I just alert the board to that.
And we have reached out directly to DOB ourselves.
Thank you, we appreciate that. And we'll forward to council the reconsideration that was filed.
Okay, thanks. Did we need to reopen in order to take that? No, that was okay.
If there are modifications required, we will, but he
No,
doesn't
but
have
just
to
in
modify.
terms of his testimony just now? No?
It's part
No.
of the record.
Okay.
No.
Okay, fine.
Okay.
Thank you.
Submission date, you should maybe put it off for until after New
We should
Year's.
put it off because we
Maybe
don't know actually,
Allow for the second week in January, maybe, after the holiday, maybe that'll give it time.
okay, you want to do that? We just schedule for the hearing in the, whatever that is, January 13th, I believe?
You want to defer to January 13th?
13th, yeah.
Okay.
Okay, and we'll submit whatever we have by January 6th, so that way you have it. Thank you.
Sure.
Continued hearing items, item number 5, 69859BZ, 2773 Nostrand Avenue, Brooklyn.
Hello, good morning again, Eric Palatnik. We attended your review session, and we do have I think it was, I'm losing track of which document it was you needed, but the
remedial
environmental remedial action plan, yes, correct. I got a copy of that late last night from the engineer, so we could submit that to the board.
Okay, so you could submit that, and so we can close this and just leave the record open for you to
Thank you.
submit. So for a motion to close, oh, sorry. Oh, I'm sorry, is there anyone from the public who'd like to speak on this?
Okay.
So for a motion to close?
Chair Perlmutter?
Aye?
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. Oh, I'm sorry, is that a decision? I guess I must be a little spacey. Let's see today. So, okay, so we could set a decision for the 9th, I suppose, on this, so we can have time to look at the wrap.
So December 9th?
Yeah, for December 9th.
Thank you.
Okay, and the submission date?
We can submit that right away. We'll submit it within a
They're going
week.
to submit right away, so the decision could be December 9th,
Okay.
because we just closed,
We did.
right?
Okay.
Okay.
Thank you.
Thanks.
Item number 6, 82259BZ, 1774 Victory Boulevard, Staten Island. You didn't collate this?
There's only one of us.
No, there's more.
They're all the same. Collating and copying are my nemesis on this application, I see. Ms. Matias is upset that I did not collate it. I apologize, Ms. Matias.
Yeah, you just pass it
And
down.
I want to apologize to the board. I know that I watched your review session yesterday, and my staff reported back. I know that the plan set that was PDF to the board through a Dropbox submission had cut off and was of poor copy quality. We do apologize for that. Of course, we could always want to provide the board with clean plans and make it easy for your review, and we'd ask, of course, if you ever counter that again, please let us know, and we'll right away have everything submitted to you the correct way. And we were unaware of that. We did have one person out last week in our secretarial division, so that was part of the problem. But nonetheless, I had printed up the plans for you once again, so that you have them clearly in front of you now, so that you can see the page numbers down at the bottom. And I've also printed up for you a bullet point response to all of the issues that you raised yesterday, which I worked with the architect, the engineer last night on, to provide a very thorough response. You had a very long list of questions. I think it might be better, it's up to you, if you want me to verbally present it, or I'll shut up for a second and let you read it. I think that's what you want.
Well, why don't you present it, that way the public can
Okay.
hear too.
I guess just starting in order of the bullet points on the email. Commissioner Hinkson raised the question of the parapet walls and the screening. The very first bullet answers that. It's, we don't provide any sound specifications because we didn't think that we were getting into an entire, like I know you have a gym on later, sound issues. I didn't think you were going that far with the discussion. I really thought you would come up with a good idea to hide the AC units and provide some kind of buffering for them. And in response to that,
It's just that in your response, you had mentioned that it would mitigate sound and noise as well as hide the units.
It will.
And so it just begged the question, if it's mitigating the sound, how is that happening? I understand that they're, probably relatively typical HVAC units, and you're providing what looks like, now that I can see it, looks like a 4-foot parapet, and we're
Right.
confident that those units do not exceed 4 feet
no,
from the roof?
they do not. And also, we've provided you with a description, of course, of the concrete block that's surrounding it. But we feel, again, we didn't provide you any technical specifications of the sound buffering, but we feel that
No, I
that
think-
will
I think
absorb
this is
and reflect
probably
sound.
This is probably sufficient. It's just that, you brought it up as being a sound
Understand.
barrier, and I was expecting then to see.
To have all the
evidence of a sound
specifications
barrier.
with the sound barrier. I'll be more specific, I apologize. The next question the board raised.
Just a question
yes.
about that, though. I assume they're going to be installed on isolator pads, because they do vibrate no matter what, right? They'll be installed on some kind of isolator?
I would imagine they would be.
Yeah, so if you could just check
Sure.
about that.
The second question was, is there a 6-foot high fence around the air and the vacuum? There is not around those specific units themselves. There is a 6-foot high fence, PVC fence, that's proposed around the entire perimeter of the property. And that extends from the intersection of the south side of the property with Manor Road and goes to the interior corner of the property and then extends northerly up to Victory Boulevard. The relocated vacuum and air stations, which was what you had requested at the last hearing, have been moved over to that space, which is, it's not dimensioned, but it looks like it's about at least 20 feet from the fence area there.
Okay, and now it's called out on the drawings?
Yes, it's called out relocated air and vacuum stations.
Yes, okay, good.
There's a note there. The next question is the widening line was not shown in sufficient detail. Hopefully, the clearer copies have clarified that for you. You could see 2 locations. It's marked, but on the right side of the page by Manor Road, right above the D in road, if you go straight up, the next set of language is the 10-foot exception for the street widening. And it points with an arrow to the widening line. So, again, we apologize for the copying. The number and types of trees and bushes are not shown. The architect replied, I'm reading his email, the engineer, excuse me, that the plans indicate, I'm going to mispronounce it, arbor vitae at 10 foot on center. There's going to be a total of 17, is what he's indicating here. We'd be happy to make that more clear on the plans if that's needs to be done.
It just says the name of the tree, but it doesn't say
A number.
how many.
We'll add the numbers.
Yeah. Okay.
I apologize, my Latin wasn't so good there either. Demonstrate compliance with ZR Section 37-21. That's the screening requirements between residential and non-residential uses, which you had raised yesterday during your review session. That there, as we cite there in our response, is that the 5-foot landscape buffer is required between the commercial uses and lots containing only residential uses. The properties to the west and south are both mixed residential and commercial, and they don't require a buffer. The properties to the southwest, I believe what he's talking, the properties to the southwest are used only for residential use, and therefore a 5-foot landscape buffer is required, which has been provided. He's talking about the building that's along Manor Road, that's a mixed use, and that requires a 5-foot buffer, and he's actually providing an 8-foot buffer at that location.
And the buffer is in the form of what?
Landscaped buffer.
Landscape buffer.
Yeah, it's the landscaping.
So it's the tree line. Okay.
Correct. And again, he shows evergreen trees which are being planted, and the 6-foot tall PVC fencing he has notes for surrounding the property. I think the next substantive question that came up yesterday was to demonstrate the location of the curb cuts and that the pedestrian walk complies with the DOT regulations. The engineer there gave a series of reasoning as to why it complies with all of the DOT regulations, which I'd be happy to read to the board.
You don't have to read them, but I'm just curious because, they give distances between a whole bunch of things, trees and adjacent driveways, but they don't mention anything about pedestrian walkways specifically? They don't say a commercial curb cut has to be at least 5 feet away from a pedestrian walkway? I just thought that was a little puzzling to me, that wouldn't.
I'll give you an affirmative statement back. I don't know the answer, and the engineer couldn't be here on such short notice.
Okay.
But I will give you an affirmative answer back that we don't need it.
All right.
That it meets the crosswalk in particular.
Because they're butting up against each other, this place.
I could see how they're close, and I could see your concern. So I'd be happy to raise that.
Okay.
The engineer. And then there was a question raised with respect to the signage. I'm not quite sure what the question was, but we've tried to clarify here, and we directed his plan sheet Z400, which gives you all the calculations.
Right, and it's still not equaling what you have as your signage notes for Victory Boulevard. You're still off, and then you're also off with your initial sign analysis form that was submitted for the first hearing.
So you're saying that you've looked at it and the Victory Boulevard frontage is off?
You're adding it up from your plans, it adds up to 52.4, and then at the top, you have 68.8 in total. And you have the same thing in your initial signage analysis plan, which is broken out by frontage, but it doesn't even label the frontage. It's just two numbers squashed into one form, which is possibly contributing to
the confusion.
Mathematical error.
All right, I'll have the the engineer go back through it one more time to make sure the zoning analysis matches up with the plans. Had him look at it this morning, and the plans he thought were correct, but you're raising an issue he probably missed.
Unless, the only thing I could think of is that this should be times 2 on your little chart at the bottom. Your bolus sign plaque should be times 2, and then perhaps that then will equal.
That may be the
up to it.
oversight.
Yeah, so that's probably
All
what
right,
it is.
it's like finding where's Waldo. We'll find the error and we'll correct it. I believe those were all the questions the board had.
Were there any other questions about this?
No?
Is there anyone from the public who'd like to speak on this item? Okay, I think we could actually close this, and then you submit these items.
Thank you.
So you could resubmit on, sorry, November. Can you submit on, well, how much time do you think? You need more than a week?
No, the engineer here is yes, we could submit within 1 week.
Within 1 week? So
Yes.
if you submit it on the 25th, we could have the decision on the 9th.
Thank you.
Okay, so for a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez.
Aye.
Commissioner Otley Brown.
Aye.
Thank you for your time.
Eric, take this. Very good. Item number 7, 90279BZ, 109679BZ, 109779BZ, and 14803BZ, West 28th Street and West 29th Street, Manhattan.
Good morning, Chair, Commissioners. Howard Goldman for the applicant. I want to address the couple of questions, comments that were made at review session yesterday. As a preliminary matter, I want to talk a little bit about the timing of this application. We keep referring to it as a 2003 application. The board's decision was made late in 2003 in October. The application was actually filed in May of 2003, and work actually began on this application in 2002. And a lot of the data and the information that went into this application date back to 2002. So just to clarify the timing on this. In 2002, of course, was a disaster. It was the year after 9/11. Chair Perlmutter asked us to address whether the development site, which is lots 30, 31, and 32, 1, 2, 3, were ripe for development at the time this application was being filed and was under consideration. And I think the answer is very simple. The development site was not even in single ownership at that time. The lots 31 and 32 were jointly owned, but the immediately adjacent lot, lot 30, which would be necessary for any zoning lot merger, was in separate ownership from lots 31 and 32. So not only, was there different ownership between the development site and the TDR site, our site, but there wasn't even a development site at that time. There were just 2 lots and 1 lot. And the adjacent lot was a 20-footer, 21-footer, and it clearly was not a candidate for purchase or development of development rights.
I think you made that clear in your papers.
Thank
You
you.
were very good.
Just a quick comment on what the hotel market was doing in 2003, because that came up. According to Landauer, in their July 14, 2014 submission, they specifically say that while there was an overall improvement in the residential market, the hotel market, they say that market improvement did not reach the hotel sector until 2014. And in fact, they flat out say there was no demand for hotel land or transferable development rights in the year 2003. So if I said 2014, I meant 2004. So finally, Commissioner Otley Brown had asked about other hotels that received their permits or filed for their permits in 2005. There's only one. Oh, Commissioner Montanez. My apologies. Well, I'm looking at Exhibit F, so maybe there are 2, but our Exhibit F lists all the hotels. And I've got the Hilton Garden on West 28th Street as filed in 2005. The next one I have on this list is actually the Hotel Indigo, which was filed in 2006.
Well, I was thinking of 121 and 199 West 28th. I guess I don't know what the hotel names are. One was filed in April 2005 and one in December 2005. And I was just, in reading the Freeman Fraser report, the argument why the community board's examples were not relevant has to do with the significant amount of time to design and develop and finance and do land acquisition.
Yes.
And, I'm thinking that could be 2 years, 3 years. So that would put 2 hotels which were being planned on West 28th Street during the same time period as the variance. So I would just like some clarification on that.
Well, I don't know the facts of those sites. I don't know when they started to be planned. I don't know when the land was acquired. I don't know how long the land was held before. But what I do know is that for this site that's before the board, in 2003, there was no transfer opportunity and there was no hotel development that was being planned. The hotel development that's before you now was born last year, was born in 2013, when the developer acquired lots 30, 31, and 32. And before that, there was nothing going on with respect to this site. In fact, the owner has submitted papers saying that he never received even a hint of an interest or an offer with respect to his development rights until 2013. And had he received any interest, he would have very happily pursued it,
Right.
but nobody ever came to him. And I think this at least explains maybe why, that there was no assemblage, no development site at that time.
I think maybe with respect to those other hotels built in 2005, unless there's a way to really track what was not built, permitted in 2005, unless there's really a way to track, for example, when the land was assembled, could have been assembled in 98, and then they started to work on it, and then the bottom dropped out, and then they held it. So unless you actually went back and looked at that history, you wouldn't really be able to make a comparison. And then I think the other thing that was addressed at the last hearing and in some of the submission was that the property was really in a state of distress. And so if someone had offered whatever the going rate was on development rights, they certainly would have taken it because the property really did need help in addition to what they got with this variant.
And then just one last fact. In fact, all of the lots, all 5 lots, were occupied by IMB tenants in 2003. And, some arrangement would have had to be made with those tenants if there was going to be a development. And at that time, there wasn't a lot of capital for people to make those kinds of arrangements.
Okay. But Commissioner Montanez, did you want some kind of a submission to respond to these questions?
No, I guess the idea of tracking, as you said, the development of the other and planning of the other hotels is not possible, even through,
We can check the public records,
Right.
Right.
which we have done. But we don't know, until it became public, we don't know what was going on behind the scenes, whether plans were being prepared or financing was being lined up. We have absolutely no way.
well, if those were, a conglomeration of different lots, could you just give us the background on when they were transferred?
We can check the deeds for those
Okay.
lots. Sure, be happy
Yes.
to do that.
And sometimes that won't reveal anything either, or they don't close until literally the day before they're ready to get going and those kinds of things. So, okay. Okay, any other questions on this? Any comments from, yes? Yes, please.
Please state your name for the record, and you'll be afforded 3 minutes.
Thank you. Hi, my name is Eric Stern, and I chair the Land Use Committee of Manhattan Community Board 5. Thank you, Chair and members of the board, for hearing me today. We support development, and we have no problem with the hotel going up at that site. The other 2 sites that are seeking amendments to the variance site plan, we're totally okay with. But we are not okay with the manipulation of the land use and the variance process in the city of New York. And I've never come before the board to speak to anything like this before because we've never seen anything like this before. We see in their plan that in 2000 there were 2 hotels, in 2001 there was 1 hotel, in 2005 there were 4 hotels, in 2006 there was 1 hotel. The applicant is asking you to really suspend rational thinking here. Let's just think about it for a second. They note how it took hotels that were online in 2000 and 2001 3 years or so to get developed. So were none of the 2005 hotels in the development stage by 2003? Just let's think about the arguments that they're making here. That doesn't really make sense. there's an assertion that they couldn't get foreseeable reasonable return in 2003, but is there any real evidence to support that? Where the rights could have been warehoused, as you mentioned in one of your prior meetings. Is separate ownership of lots the only reason? I mean, there's separate ownership all the time. Lots get assembled all of the time for development. This is Midtown Manhattan. That is not a valid argument here. And just one point, Landauer initially said that the current development site could not be developed in 2003 because there were rent-stabilized tenants there. Well, those rent-stabilized tenants are being bought out here, so I don't see how that was impossible to get around in 2003, and now magically is possible to get around here. I would bring up the issue of Grand Central for a moment. Grand Central has a lot of development rights that are able to be transferred. And if today there's no one, as is the case, offering them money for those development rights, does that mean that those development rights are worthless? The applicants would have you believe that if there's no willing buyer today, then development rights are worthless. Well, that finding would stand in stark contrast to what the Supreme Court found and what the city needs to have be the law in order to justify the landmarks law and to justify overall transfer of TDR from landmarks and from other sites. So there are major issues here to consider. I would draw your attention to 1999 condo documents submitted to the Attorney General. They explicitly retain power to transfer development rights by the property owner. So this is, I don't know if this was information that you've been presented with before, but these are relevant facts. Did the 2003 BSA have access to this? Did the 05 BSA have access to this? There are many open questions. And I'm sure to your point, could they have sold their air rights in 2003? If anyone was willing to buy, why wouldn't they have sold them? Well, in 1999, they retain, and actually not just retain, but they identify 2 different plans to develop residential on top of their building. Those plans, were they disclosed to the BSA in 2003 when the initial variance was granted? I don't know, but they came back to the BSA in 2005 to seek that amendment to the variance. So there's a question of what was known by the BSA in 03, what was known by 05, and sort of these are sophisticated property owners who are taking a long game here. 99 identifying their development plans, 2005 building, 2003 seeking a variance for a higher and better use of residential without without consideration for school seat capacity, parking capacity. I mean, our community district is really overcrowded, and there's a cumulative impact to all of these residential conversions. I would say.
Just wrap up.
Yes, I will. So, yes, I will. I would say there's major precedent here to be considered. If you approve this as is, then let me give a scenario of what could happen. If there's a slight market downturn, and there's no common ownership of adjacent lots, and you wait 10 years, anyone can get a variance to convert to some sort of a more valuable use, and then 10 years down the road, get a Landauer to make a report and get a variance to transfer all the unused development rights. There's really potential for adverse impact here, and I would urge the BSA to consider that. There's major precedent here. The other cases where this similar action has been granted is when 20, 30, 40 years ago, there was a variance when there was really no foreseeable development. When we look here, there was clearly development going on 2 years before, 2 years after. And just in closing, I would ask for denial here, and if a denial is not granted here, I would really ask that the public hearing be continued, not just open for comment, but that the public hearing be continued. I, as chair of the Land Use Committee, did not have electronic access to these documents until Friday, and I understand there might not be sort of formal obligation, but I wasn't able to go to the board office and get the physical copy, and so I've not had full time to articulate all of the arguments that I would like to articulate here, and I would really ask that we be able to have a further conversation in a public hearing capacity on this. It's a really important issue, and I urge the board to use common sense and common judgment about how long does a development take? If you can't sell it immediately, does that mean it's worthless? No. Thank you.
Thank you.
I'd entertain comments
Thank you.
questions if you have any.
Okay, thank you very much. Okay.
Okay, that's it. Okay.
Mr. Goldman? Is there any other speaker on this?
Thank you. A brief response. And we always appreciate the community board's input on these matters. The condo docs, what Mr. Stern cited, is a standard provision in every New York City condo doc regarding the retention of development rights. There was no plot, there was no scheme, there was no crystal ball. It just would be imprudent lawyering not to reserve the development rights. So that's common practice, that there's no significance to that whatsoever. Secondly, Grand Central is lovely, but the relevant case here is Bella Vista. and we are operating under Bella Vista, and Bella Vista says the board should go back, look at the time the variance was granted, and see if those unused development rights had substantial value at that time. In Bella Vista, the fact of common ownership was not disclosed to the board. The transfer was made 3 years after the variance was granted, and it was basically, as I said in my papers, there was some hanky-panky going on that the courts didn't like, and it has nothing to do with the facts of this case. Finally, my client is sitting here. He's unaware of any plans to build above this building residentially. He's never heard of any such plans. I don't think that that's factually correct. Last response, this will create a terrible precedent. No, this is exactly what the board should be doing. When a variance is granted, it puts the building receiving the variance on the same ground as other buildings that don't have a hardship. And any of those buildings can sell their development rights when the market is there. So there's no reason for the board to lock up the unused development rights unless the board feels that it's giving such a great value to the property that the value of the development rights should be, cut off at that time. And I'm not aware of that ever having happened for the board. So we spent a lot of time with this community board. We went to meetings, we had discussions, we submitted papers. There was a different land use chair at that time. And we're going to insist that, or we're going to request that the board close this hearing. It's enough already. We're happy to submit the information Commissioner Montanez requested, but we are very much against keeping this open for yet another round of comments. Thank you.
Sorry, only one time for each speaker. Only one time for each speaker. I'm sorry,
He can
that's the
respond in
procedure,
writing.
right?
He can respond in writing.
Yes, right. So just 1 second. Actually, Mr. Goldman, because we need to have the applicant here while we're just. So that the community board has a chance to submit their testimony, which they haven't done other than their resolution, we can keep the record open, okay? But we also need for you to submit your response to Commissioner Montanez's questions, okay?
That's fine.
And if you want, you can also submit responses to notes from what the community board said. You can listen on the video and pick up all those comments.
Very good, thank you.
Okay. So the community board will have a chance to submit something into the record, but I'm sorry.
A question?
You can address the question to Tony Matias at the end of the hearing, okay? Yes, sir. Would you like to speak?
Oh, am I supposed to sign in with you?
No, just to state your name.
Hi, my name is David Sinclair. My wife and I own the unused air rights that we would like to transfer. We live at 111 West 28th Street, where I have my business, and I have lived since 1997. We're raising a family, twin 20-year-olds in college and twin 6-year-olds in elementary school. I bought the building with the IMD tenants in 1999. And together we rebuilt the foundation and we legalized it as a condominium. We did have in our operating agreement plans that if we were, how we would go about ever developing the building, if that was possible, but it was pie in the sky. And obviously at the same time, we had reserved those air rights, and we own those air rights. But we legalized the building and converted it to a condominium with the tenants that were there where we lived together. Things were bad in our neighborhood in September 2001 after 9/11, and the tenants couldn't pay their rent, and the flower designers moved out, and they moved out of our building and out of 28th Street. In 2003, things were still bad, and so we applied for a variance. and we received a variance to convert part of the building to residential use. And at the BSA's suggestion, we kept the 2 lower floors commercial to support the struggling flower market. We want the new hotel to be good for the community. The developers agreed to leave open space in the rear that is protected from the street, and they've agreed to plant trees on the sidewalk. They've agreed to provide a scholarship for flower designers and for exhibitions. We have 28 letters of support, which includes a letter from Michael Gaffney, who's the owner of the New York Flower Design School. Our condominium is called the Flower House Condominium. We are in the flower market, and we feel still part of the flower market, even though it's much smaller than it used to be. And we've always played by the rules, and we've tried to be good neighbors. In 2003, we did not ask more of a variance than what was absolutely necessary to overcome the unique conditions of our building. We explored the potential for selling unused air rights at that time and found it was impossible. There were no buyers and there were no adjacent developments. Our economic consultant, Mr. Freeman, and ultimately the BSA agreed with the conclusion that the development rights had no value in 2003. The only reason that the development rights have any value now is because the enormous changes in the real estate market that have taken place since 2003, and these huge multiples of value are what allow now the development site next to us to be able to buy out those IMD tenants. It was something that wasn't possible 11 years earlier. My wife and I would respectfully request that you please approve our application. Thank you for your consideration.
Thank you. If you have something in writing, you can submit that, unless that was just notes. Okay. Oh, yeah, you can submit that if you want. You can submit that to Ms. Matias over there. Okay. Are there any other speakers on this item who haven't spoken yet? Okay, so just again, for the community board, please submit in writing, and then Mr. Goldman, come back to discuss the timing. Okay, so if the community board could submit by December 9th.
Can I ask that we have an extension? We're dealing with Eastern Town.
Sorry, we can't delay the hearing. We have to have a submission. You already had things to say, so just put that in writing. And also, Mr. Goldman, if you could submit your materials by December 9th for decision on the 16th?
I would be happy to do. We can do that.
Okay, sorry, I'm sorry. If you have questions,
You can speak to-
you really need to speak to Ms. Matias on the corner, because we're trying to conduct business here, okay? All the submissions will be on the 9th for decision on the 16th, and we're going to close the hearing and keep the record open, okay? So for a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Decisions is 16.
Thank you all.
Next item, item number 8, 96487 BZ, 786 Burke Avenue, the Bronx.
Hello, good morning, Eric Palatnik. We attended your review session yesterday, and we watched your video, and if they still call it video, and we heard what your board, your comments were. Particularly, I think there was a question by Commissioner Hinkson about the number of bays that are being retained. There are 3 being retained.
There are 3 being retained.
Correct.
Because I think somewhere in your facts and findings, you actually say there are 2 being.
I looked through that last night. I couldn't find it, but I'll go back through and I'll look at it again, and we'll fix it.
Good.
I think you had asked for more specific information on the plans, is the same as the earlier automotive service station with respect to specificity on the landscaping, and we'd be happy to provide that for you. The engineers have a learning curve with you, so they're catching up quick, though.
Trying to keep them on their toes.
No, they deserve to be. And I believe there was a question about the fencing. We are proposing to fix up the fencing. We have not done it. We just cleaned up the site before this hearing. But upon approval from your board, we'd like that to be a condition because we'll be doing extensive site renovations at that point. That's-
And there was also a question about the signage calcs also?
Oh, with respect to, that's right, I think it was Commissioner Ollie Brown's question with respect to the flags that they have at the pumps, right? Those are temporary, they shouldn't have been in there, those should not be there. And we'll have those removed, and we'll give you some pictures of it.
Okay. Okay, are there any other comments on this?
Just to clarify on the fencing, are you going to show on the plan new fencing, or are you just repairing?
New slots, we were going to put, it was a slotted fence, we were going to put new slots.
Okay, and where the fence is so degraded that one needs to replace
We'll
a section of,
so
you're going to do?
how about we include a note that says fencing to be repaired as needed or repaired or replaced
And new-
is needed to like new
slots
condition or
throughout.
something.
Yeah.
Are there any speakers on this item? Okay, so I think you can actually make these submissions and we can close the hearing.
Thank you.
So if you can, how much time do you need for that?
We'd like to submit the week after Thanksgiving, just, we have a few that are due before.
Okay, so that would be a submission on the 2nd? Oops, I'm sorry, I'm in the wrong year. Submission on the, it'd still be the 2nd. Does that work for you?
December 2nd is fine.
Yeah, okay. For a decision on the 16th. On the 16th.
Thank you. Thank you for your time.
Motion to,
So I had a motion to close the hearing?
Chair Perlmutter,
Aye?
Vice Chair Hinkson,
Aye.
Commissioner Montanez,
Aye.
Commissioner Otley Brown.
Aye.
Thank you.
Item number 9, 20392BZ, 70-20 Austin Street, Queens.
Good morning, Chair Commissioners. Jeffrey Chester for the applicant.
I don't think we had any comments on your application. Are there
I didn't see
any
any.
now? No. Are there any speakers on this item? Okay, so I think we can close this. We have all the submissions. Da-da-da. Okay, so we can close this.
Chair Perlmutter,
Aye.
Vice Chair Hinkson,
Aye.
Commissioner Montanez,
Aye.
Commissioner Otley Brown.
Aye. Thank you.
Is this put on for a vote?
Yes, of course. Silly me. Okay, 2004. Okay. So we can have a decision on the 9th, December 9th.
Thank you.
New cases, item number 10, 83352BZ, 5916-30 Foster Avenue, Brooklyn.
Good morning, Hiram Rothkrug for Vassalotti Associates. I heard comments from executive session yesterday, and possibly there was a submission that we made that the board was not aware of, or because I submitted it wrong electronically, it was the case might have been distributed before the board had an opportunity to see response to last comments. For instance, the wrought iron gate that was mentioned at the hearing yesterday had been removed from the site. It's no longer on the site. These are noted in our photos of September 2014 that were submitted to the board.
Now, there were two sets of photographs, and one set hadn't been removed, so that's part of the confusion.
No, I
I
understand. And also part of the confusion is when we originally foiled the prior case from archives, they couldn't locate the folder, so we didn't have a copy of the prior approved plans. So that also caused some confusion on the comments that we initially received from the board. So just to go over things, the barbed wire fence is from the site next door.
Okay, so not under your control.
It's not under our control. The lattice in the fence is all there. It's all been repaired and fixed, which was mentioned
Okay, so if you
yesterday.
could provide photographs that show
I-
that, because the old ones don't. Okay.
Correct. The wrought iron gate that was mentioned has been removed from the site. Additionally, the site, we don't have a wall. There was some mention about a wall on our site that needed repair or something. We don't have a wall on our,
Okay, oh, it's the neighbor's wall that,
it's the neighbors.
and you're not permitted to paint it or anything like that? I mean, it was, no. So in your relationship with the neighbor, you don't sometimes, like, who painted it to begin with?
Well, you know what, I'll try to find out, because we're just leasing the site from the owner, so we don't have, we don't have
Okay.
control over that, but I'm I'm happy to reach out and advise the board and see if we can do something about that.
Because it would just make it look less shabby if you could.
Sure. Additionally, on our new proposed plans, we're reestablishing the curb cuts at the prior approval by the board to 30 feet.
Okay, but the comment there was that that was the case in the prior approval, and they haven't been reduced since, so we really do need to condition permitting on
Sure.
the
Sure,
reduction of the
absolutely.
curb
And
cuts.
that's shown on our proposed plans that we
Right,
submitted.
right, but it was also on the proposed plans from the last
Okay,
approval, so,
I understand.
okay. Okay, are there any other comments on this? Okay, are there any people from the public who would like to speak? Okay, so I think we can also close this item, and you submit hopefully clear photographs of the slats that have been replaced, because maybe that wasn't clear in any of the photographs. And just to clarify on
On the wall,
the wall, yeah.
great.
Okay, so we could set a decision date, so a submission date on the 2nd of December, and for a hearing on the 6th, for the decision on the 16th.
That's great. Thank you very much.
Okay, and so, sorry, 1 second. Oh, no, prior to permit, yeah. Oh, no, that's a lot of work. Okay. Okay, so for a motion to close?
Chair Perlmutter,
Aye.
Vice Chair Hinkson,
Aye.
Commissioner Montanez,
Aye.
Commissioner Otley Brown.
Aye.
Thank you.
Item number 11, 16404BZ, 2241 Westchester Avenue, the Bronx.
Good morning, Josh Rhinesmith of Warshall Burstein for the applicant. This is an application to extend the term of a special permit that was originally granted, I believe, back in 2004. I believe from yesterday's review session, there were a couple issues raised regarding discrepancy in the statement of facts regarding the fire alarm and sprinkler system. The PCE does have a functioning fire alarm system. It's been approved, permitted, and signed off by the Department of Buildings. And as you noted, I had mentioned that in a letter to the community board. I will submit the copies of those applications to the BSA in subsequent submission.
And
a
amend the
revised
statement of facts.
Yes.
Okay.
There was also a question about a violation that was issued in September for an air conditioning unit. We're still trying to work with the property owner to get to the bottom of that violation. We had removed all violations of record, and then just as we were about to submit our notice of comments response, this one appeared, and we're looking into it, but I'm hopeful we can have that information very soon.
There was an ECB hearing scheduled for 10:31.
I'm sorry, what's that?
There was an ECB hearing scheduled for 10:31.
Okay, I'll look into it. Yeah, I mean, I
Hopefully
don't.
somebody appeared at that hearing.
I hope so too. I don't represent the property owner, and so I didn't even have, I wasn't aware that they weren't going to attend. My hope is that they did. And
Are
then-
those AC units related to this facility, or it's something?
Well, there are several AC units on the rooftop, and we're trying to figure out which one that violation may have been in response to. And then lastly, there was an issue about graffiti. We had arranged for the removal of the graffiti in September when we submitted our notice of comments. I was curious as to whether site visit showed that additional graffiti was back on the building.
Yes.
Okay, so that's something
So
we've
on the
had.
roof, it seems like if you look at that building and the neighboring buildings and the building across the street that's right by the subway station, it looks like it's a serious problem.
been an ongoing
It's
problem.
Yeah, you're
So-
going to have to just stay on top of.
We'll work with it, and we'll speak to the landlord and see if we can come up with a plan, and we'll submit the details of that. It's probably going to require monitoring and being out there every month at the
Yeah,
minimum.
Basically.
Did you get a vote from the community board? I know you sent them a letter.
We sent them a letter, and they had issued a resolution in support of the application. I have a copy of it back at the office. I'll submit that along with my submission to the board.
Okay, so how much time do you think it'll take to cure up this question with the violation?
If we could have 3 weeks to submit,
3 weeks?
I think that
That'd
would be
great.
sufficient.
Okay. Okay, are there any speakers on this item? And no other comments? Does anybody have a problem with it closing and we just wait for the submissions? That's fine, okay. So we can close and give you submission, 1, 2, 3. So if you submit on the 9th of December, we can have a hearing on this, a decision on the 16th. Could you submit by the 9th?
Yes.
Okay, because otherwise it's not until January.
Yeah, I appreciate that. We can definitely do so.
Okay, so submission on the 9th and hearing on, decision on the 16th, and for a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you very much.
Appeals calendar, continued hearing items, item number 12, 300-08A, 3935 27th Street, Queens.
Hello, Ashley Halen for the applicant. We requested an adjournment, I believe, for December 16th.
Right, and with a submission on the 25th, does that
Correct.
work for you?
Yes, that works.
Okay, great. Thank you.
Item number 13, 9514A, 237 East 76th Street, Manhattan. We have
I don't know if there's anyone here for this, but we are going to adjourn this until January 27th with a submission on January 13th.
New cases, item number 14, 265 through 267, 14A, 3740, 3742, and 3812 Atlantic Avenue, Brooklyn.
Deborah Helene Morris from New York City Housing Preservation and Development. We attended the pre-hearing session yesterday, and we have already addressed your comments.
Yes, thank you very much. Okay, so we can close this for a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
And then we can also vote. So for a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Thank you.
Decision items, zoning calendar, decision items. Item number 15, 32313BZ, 127 East 71st Street, Manhattan.
Oops, I don't think Eric is in the room. Okay. I didn't need him on this. Okay, maybe we,
Yeah, they don't have these LPC sign off.
right.
Obviously, but
You're not allowed to leave, you're
I
every other.
apologize.
I
You
know.
moved very quickly. I didn't expect you to go so quickly.
Okay, so this is for 127 East 71st Street, right? And so what's happening with the CD?
Oh, we would love your help. We're stuck. The former chair of the BSA would be upset if she learned what's happening. We got the approval the same day we had a hearing with you on September 23rd, and we've been communicating with their staff, Ms. Shayel, I forget the last name, who's writing the certificate of appropriateness, and we're on that schedule of when that person gets to doing it. We've nudged and we've nudged to the point that we can no longer nudge.
How long ago was your hearing?
September 23rd. It's nearly 2 months. And we have asked, and we've spoken with council at Landmarks
But
and
you've already submitted construction documents?
to Department of Buildings.
Yeah.
No, we're waiting on the certificate of appropriateness right now. The building is under construction right now under as-of-right work. But,
Okay. But is there anything missing from your filing at LPC?
no.
Well, you modified your plans, though,
Yeah.
to us.
Again?
No.
At the
No.
rear, you know,
Because we.
No, we didn't make any modifications to the rear.
Nothing was modified, was it?
No.
We did?
the second floor greenhouse at the rear.
No, that was removed already. That wasn't in the
That was
filing.
prior?
Yes.
Oh,
Yeah.
okay.
And that was under
Let's
subject
keep
to
that now.
Landmarks. We're waiting on Landmarks, so it's all about the certificate of appropriateness. We've pushed, we've nudged.
Okay.
We did have the community board meeting last week, the committee meeting, which was the third community board meeting we've had on this matter pertaining between Landmarks and this application. They approved it unanimously, committee, and the full board will be tomorrow night.
Okay.
But
Oh,
the full board
still hasn't-
is tomorrow night, so the adjournment for a week is not, it's not the end of the world as far as our application goes, and hopefully Landmarks could,
Okay.
with a little push, can get this done today, this week.
Okay, so we have to defer decision until we get this. How about we give it a couple of weeks and see how that goes?
If we could, to the first week after Thanksgiving, and maybe in the interim, again,
Okay.
I'd ask the board, maybe you could use a little inter-agency.
Okay, we'll try, do what we can,
Discussions.
given our friends in high places. Okay. So we'll defer this to the 9th of December for decision.
Thank you.
Item number 16, 9314BZ, 455 West 37th Street, Manhattan.
Hello, Eric Palatnik again.
For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Item number 17, 9714BZ, 2226 East 14th Street, Manhattan.
Josh Rhinesmith for the applicant.
For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Item number 18, 100-14BZ, 1490 Makems Road, the Bronx.
Hiram Rothkrug for Rothkrug Inspector.
For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Great, thank you.
Item number 19, 10414BZ, 282 South Fifth Street, Brooklyn.
Josh Rhinesmith.
What happened to that one? For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Thank you.
Item number 20, 15014BZ, 30 Broad Street, Manhattan.
Good morning, Madam Chair, Commissioners, Frederick A. Becker.
For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you very much.
Item number 20, continued hearing items. Item number 21, 15311BZ, 27-11 30th Avenue, Queens.
Hello, Eric Palatnik.
Aye. Did you want to adjourn this?
Yeah, for 2 or 3 weeks, we just got photos yesterday of the lifts having been removed, the outdoor lifts.
Okay.
And we have a couple more small items to attend to. So we could submit in the middle of December.
Like the 9th or the 16th?
The 16th would be great.
So, okay, so you submit it on the 16th, but we don't have a hearing again until the 6th of January, is that okay?
That's great, of course.
Okay, so adjourned for submission on the 16th and the hearing on the 6th.
Thank you.
Thank you.
Okay. Item number 22, 2-13BZ, 438 Targy Street, Staten Island.
Good morning, Alfonso Duarte for the owner. I'd just like to take this time to publicly acknowledge the staff who's doing a terrific job in preparing these cases for hearings. I've appeared before the board for over 40 years, and the staff has always maintained an A rating as far as I'm concerned, and I'm sure some of the other applicants will also tell you the same thing.
Thank you, that's very nice.
As far as getting back to the Taji Street, at the last hearing, the board had requested some gluing together all these submissions that were submitted previously. In fact, there were 3 previous submissions. And in the 4th one, which I just submitted, I tried to tie together all of those data. As far as uniqueness, I believe that we show that the lot is unique, even though there are similar triangular plots in the area. Some are larger, some are smaller. One of the smaller ones got eaten up by 6 other tax lots and made one zoning lot out of it. The other ones are much larger than this lot. There are over 1,000 square feet. One was built prior to the 61, one was built after 61. Along the end of the block on Taji Street, where the site is, there is a development that was done prior to 61. It's a mixed-use building. They have no front yards, and that's how they fit that building in under the old 1916 zoning. As far as the financial analysis, I believe Ms. Sigmund has illustrated that by utilizing the vacant portion, the owner would receive a reasonable return, whereas a residential development would be a negative return. And just to leave it the way it is, there's just a slight positive return there. So the ideal condition is to utilize this section that's now vacant. The condition was not created by the owner or a previous owner, but created rather by the change in zoning from a business zone to a residential zone. In my investigation in that area, I believe that that side of Taji Street could have been zoned C1 because there are commercial uses along there. Taji Street is a superhighway as far as I'm concerned. There's 2 lanes with parking on either side. I've stayed there at 3 o'clock, and just the cars just come zooming down, going from one red light or green light down to the other intersection. It's not a place where you would want to put a residence and have your children run out in the street to play. It's just not suited for that. Let's see. The variance requested, there is no adverse effect to the community because basically most of the sites, if not all, are developed. There's a 20-foot strip behind the subject property which cannot be developed because it's undersized. And I believe that the use of the retail store or food market would not have an adverse effect. In fact, I spoke to the owner last night, and I know one of the things that came up were the hours. And I asked him, what hours do you maintain? He says, well, Monday to Saturday, we go from 7 a.m. to 11 p.m., and on Sunday from 7 a.m. to 10 p.m. And I asked him, well, why are you open so late? He said, well, we're busy, and everybody likes me over here. So I believe it's really a benefit to the community to have this store open and available to provide all the staples that people need for their house.
I was talking about the additional store, not the existing store.
Yes.
Of the proposed hours for, and
Well,
you have a
we
food
we really
store.
don't know, because basically, that vacant portion could be used by a use group 6 occupancy. That use will be determined by the community. If it's a viable use, beneficial to the community, they will succeed. If it's not a beneficial use, they will go out of business.
So you don't have a tenant right now?
We don't have a tenant right now.
But it wouldn't be a 24-hour use.
The retail store, I don't think it would be. If
And
they
I-
sell clothes, I don't think they would be, they would close
I know that
normal hours.
The community board requested that there not be any alcohol sales.
Know what?
Alcohol sales. in
Oh,
the
okay. All right.
Okay, so
That's-
we could make
that's
that
okay.
part of the condition, so no.
But as I said, the use will be determined by the community like any other business.
But it is a residential neighborhood, and I know we did get one complaint about, late-night hours, and so it would
Well-
probably be in the order of, say, 8 o'clock to 10 p.m.
For the new
Or
use,
how about the same as what the existing use is? 7 a.m. to 11 p.m.
Okay.
during the week and until 10 on Sunday.
So the hours
So-
would not exceed what is
Yeah.
happening at the moment. So
the food
11
market
p.m. to
hours
10 p.m.
are a benefit to the community. That I believe otherwise he wouldn't stay open if he's not making any money there at those hours. So he says, no, we're busy up to those hours.
But
As
the
far as
issue is the neighbors also, that you don't
Yeah,
want to
the
open until
retail-
3 in the morning because that's annoying to the neighbors.
Well, I think that since the owner occupies the food market, he would want someone next door to him who's going to be an asset, not a detriment
Right.
to the community. And I'm sure he'll hear about it if it is. And I'm sure the board will hear about it also.
Okay.
And I had a question about your comments about the signage on the existing food market. I know on the signage analysis, you put down that it's only 12 square feet. But when I look at the existing sign, it's a very large sign.
On the food market,
Yes.
the sign there is contrary to the zoning.
Okay.
That we agree upon. And the revised drawing that I submitted shows the address, I believe, or the food market sign in compliance with the zoning resolution for signs on awnings.
Okay, so
I
you're
did submit
saying
a
that
revised-
he's going to change the sign, and it's going to be 12 square feet?
That's what the law allows.
Well,
awnings.
unless it's not an awning sign. You could have a flat sign.
Well, he may put a flat sign, I don't know, that would come later,
the
but
sign is
it
gonna
would
have-
comply with the C1 district area.
Okay.
And the retail store next door, I laid out also that it would comply with the C1 sign requirements.
Right. Okay, so you're removing that non-complying sign, is that what I
Pardon me?
understand? You're removing the non-complying sign, is that correct? Of the
Well, if the
existing
building
store?
department tells him to remove it, he'll have to remove it. Yes.
Okay, so at the moment, there's no violation on the sign, is that what
There's
you're
no
saying?
violations, there's no complaints, there's nothing. No.
But in looking at the existing signage, it
looks
does
like-
not comply.
Right, so that's part of the thing, right? It's a variance for the entire site, really, right? Even though I know it's just for that little area.
Yeah,
You
I
need to
believe
be in
the va-
compliance with zoning.
I believe the variance will state that the signs will have to comply with a C1 district. And if he has to change the awning sign, he'll
Yes.
have to change it to get his C of O.
Okay, so we're going to condition the determination on compliance with signage regulations, okay?
Could you add one thing to your site plan? I know in your existing, you have an area in the side yard for, I guess it's a trash enclosure, but you don't have it on your proposed plans? Oh, you do?
On
I'm
the s-
sorry, I take that back. In the side yard, you have, it's a trash container there?
Do we have what?
A trash container.
I don't understand.
Trash, garbage?
Oh, trash garbage, oh. He has I think a receptacle in the yard
Okay,
that he keeps off the sidewalk.
right. okay.
Yes.
That's good.
Yes.
All right, that's good, thank you. And it is on your
That little
plan?
yard, then,
Yeah.
okay. All right.
I think that's about it.
I think that's it. Are there any other comments on this? Are any speakers on this item? Okay, so what we can do is, you do need to submit just one little statement that says the hours of operation of the store, and that it will comply with signage requirements. So I think that was it, though, right? Mm-hmm. Okay, and other than that, we can close the hearing and set a decision date, okay?
Okay.
So you can you do that within a week, you think? Or you need more time? All right, so.
Get it in, I think 2 weeks would be
2 weeks,
would be
okay.
good.
So if you submit that on December 2nd, does that work?
Get it in by December 2nd?
Yeah.
Yes.
Then we could have a decision on December 9th? Is that
So
good?
what was the second date?
December 9th.
December
Shall we
9th.
do the
So
16th?
submit on the sorry?
16th? Shall we do the 16th?
16th you prefer? Okay, December 16th is better
December 16th.
for decision, okay.
Okay.
Okay, so a motion to close?
Chair Perlmutter?
Aye.
Thank you very much.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. Thank you.
Item number 23, 17413BZ, 2449 Morris Avenue of the Bronx.
I don't know if anyone is here on this, but they requested an adjournment, so I hope they're able to submit today because the submission date is today. If they want the adjournment for the hearing on the 9th, we'll find out, I guess.
Do we next? Call the next case?
Yeah.
Okay. Item number 24, 19313BZ, 4770 White Plains Road, the Bronx.
Okay,
Phew, this one's a mouthful, 4770 White Plains Road. Eric Palatnik, we've been conversing quite often with your legal counsel, Mr. Bean. He's very familiar with some issues we're confronting right now, and he's given us some good advice. We'd like to pursue that, and I think you had mentioned yesterday, take a case off calendar, I think.
no, that was the next one.
Yeah, I think they got mixed up, though. This is really
Oh.
the one, not to correct Madam Chair, but this is the one I think that should come off. This is the one that we're waiting on something that's beyond our control to respond to.
Okay.
And once we get a response back, we'd very much, without prejudice, like the ability to come back onto the board's calendar.
That's fine.
Also, I just say as a note, just for the record, if we are not able to solve the issues with Department of Buildings, we'd like the opportunity to sit down with your staff. You know, we can meet with you as cases and hearings, but with your staff to talk about other directions for the
Absolutely.
application.
Okay, that's fine.
So yeah, if you wanted to take that off calendar,
Okay, so we
So we're
can
gonna
just
off
take it off the
calendar?
calendar. Okay,
Okay.
that's fine. And then we can figure out was supposed to have happened on the next one.
Yeah, I don't need to waste your time while I pursue
Okay.
Department of Buildings.
Okay. So you can call the next item.
Okay, item number 25, 13BZ, 2472 Coney Island Avenue, the Brooklyn.
Brooklyn, that's good. It is Brooklyn. Eric Palatnik for the applicant. This was the application, I think, yesterday that you referred to that you might want to take off of calendar, but as you can see, it's only been on for one hearing so far. So we're asking it to stay on the calendar. We didn't submit because we didn't have the plans on time. I received the plans a couple of days ago. Unfortunately, they need tweaks and revisions to them. So with the board's permission, I'd like to put on for an adjournment to submit after the New Year's to allow me time to get the plans and tweaked a little bit from the
I
architect.
think I actually read tweaks and submissions as really not ready to submit.
Yeah.
When I think
Oh,
of
this-
tweaks and submissions, there's a lot of work left to do.
It needs,
so-
it needs to be amended, the plans. They meet with my satisfaction, and I know how particular you are.
Okay.
I'm going to try and get the architect to hand draw them if I can, but
Depends on the age of the architect. He might be happy with that request. He still has the tools. Okay, how about, if we did a submission on, submitting on January 13th? Would that
that would be
work?
fantastic.
And then for hearing on the 27th.
Thank you.
Any speaker?
Oh, speakers, we're just adjourning.
Oh, that's true. Yeah, okay. Sorry. Item number 26, 254 13BZ, 2881 Nostrand Avenue, Brooklyn.
Morning, Madam Chair, Commissioners, Marvin Mitzner, the applicant. I believe at the executive session, Madam Chair, you had some comments about the layout of the building. Let me just take you back to how we filed this application. Our original application called for underground parking, and the board's reaction was that the additional construction costs and mediation costs attendant to underground parking increased the need for the amount of variance required. So in response to the board's request, we removed the underground parking and placed 100% surface parking. That had certain consequences. One of the consequences was that in order to allow for maneuverability in location of the parking spaces, we needed to cantilever the ground floor. And that's what we've done. Another comment that was made by one of the commissioners in prior hearings was that the width of the building was super large. It was 148 feet, only providing one 12-foot side yard. What we've done now is we've reduced the width of the building to 125 feet, which puts it in compliance with zoning with respect to that parameter and obviates the need for one of the variances that we've asked for. That created, based upon the zoning requirement for a 125-foot side yard, we need at least two 12.5-foot side yards on each side. What we provided is 20 feet on one side and 15 feet on the other, which puts us in compliance with the side yard requirement so that we've obviated the need for that variance. Also, to address another comment made by one of the commissioners, the cantilever allowed us to reduce the cellar size, which again reduced the cost of remediation and allowed us to develop the building that we're presenting now. This is a significant departure from what we presented to the board. We came in with a 2.4 FAR building. We're now down to 1.7. We've eliminated two variance requirements, the street wall width as well as the side yard requirement. We've decreased the floor area of the building from 31,000 and change to almost a little less than 22,000. And we've reduced the height of the building from 50 feet to 40 feet. So that the layout of the building at this point is dictated by some of the concerns that the board raised that we've addressed and responded to, and in an attempt to get the minimum variance needed. And I think we've accomplished that.
So the only thing is about neighborhood character. How do you respond to neighborhood character?
Well, the neighborhood character is identified by the mix of uses and the mix of buildings in the area. On Nostrand Avenue, you have a mix of larger buildings and some smaller buildings. I would point out to the fact that in 2007, I believe it was, this board granted a variance across the street on Nostrand Avenue for a building that was 4 stories, 15-unit building. That was an FAR of 2.37. And in fact, 2 of the commissioners sitting here today voted in favor of that application. More recently, the property next to this site, in a synagogue, received a variance recently. It was a 4-story building, 52 feet in height, which is taller than what we're proposing, and occupying almost 100% lot coverage, whereas we're providing a lot of open space around our building. And that was an FAR of 3.75. And in fact, 3 of the commissioners sitting here today voted in favor of that application. So I think when you talk about character, you look at 7221, it talks about essential character of the neighborhood. And I think in that context, we comply with that. We meet the essential character of the neighborhood as identified by a mix of buildings, including the 2 buildings I mentioned, which are variant buildings, as well as other buildings across Nostrand, which are as of right, are pre-existing 7-story and 6-story buildings.
What do you think essential character means?
It means you look at what the neighborhood is and see if this particular project would change that. And if you have a neighborhood that has a mix of uses, in this case, if you have properties both adjacent and across from the building that are similar, then you can't say that this particular development will change that essential character.
So it's only related to a couple of properties here and there, though. What about others that are around, immediately around the site?
Well, I can go further. There are other properties further out that also show a mix of uses in terms of larger buildings, and certainly there are smaller buildings facing the other street, okay? But that, again, it's not Nostrand Avenue, it's the street on the opposite side, and that's where most of the smaller buildings are located. And what we've done is we've pushed the building forward. We have a front yard waiver request. We pushed the building forward to provide as much a buffer in the rear as possible.
Because you have a shallow lot, that's...
Yes.
Right, okay. So I think one of the comments was about the kind of the austere character of the proposal, right? For instance, there's no plantings because it's all turned into parking. I mean, how do you sort of soften what is ultimately a very unfriendly project?
Well, we do it in a few ways. We do have a landscape plan that I can present to the board,
Please.
which shows landscaping, if you look at it this way, shows landscaping on both sides of the property and in the rear. So that provides a
Was
soft...
that submitted already?
No,
No.
we just finished it, actually.
Okay.
So
What do you know?
We will be submitting that.
Okay.
In the other context, we haven't presented a facade design for the building. So all you've seen is like a blank wall.
Right.
But that can be treated.
Yes.
And I've spoken to the architect, and if this is something the board would be amenable to, we could treat the facade to make it look and feel as if it were a series of townhouse buildings, for example. It would soften the facade, soften the context of the construction, and make it look and feel a little different than just a blank wall.
Yeah, so that's a big part of it. You know, when you talk about neighborhood character and essential character, the whole idea is that when you build a new building on the site, and especially when it receives a special approval, that not only does it not alter the essential character, but that it doesn't do harm to the essential character, right? So it should be something that's an asset, not a detriment. And so the way that it's been depicted in the drawings, I wouldn't consider it an asset. So that's where the aesthetic aspect comes in, right?
Right. It hasn't been
Planting.
depicted.
Right, okay. So at the moment, it has zero aesthetic. So I think the next part of the job is to find an aesthetic in addition to the planting.
As I mentioned, we're prepared to do that by giving you a pictorial of the facade and how the building would look in that
that'd be
context.
good. Great, okay. Any other comments about this? No?
Just you had changed your plans this go-round, and I know you said it had something to do with light and air requirements on the first floor.
Yes.
But I thought it was better to push the parking to the back to leave the side yards open for the plantings.
Based upon my discussion with the architect, when we created the cantilever initially, we created, in the simplest way possible, which created some light and air issues for windows under the cantilever, required windows. What we've done now is just modified the cantilever by creating a small cantilever in the back and one on the side, which obviates that problem. It's just an adjustment that was dictated by the light and air requirement.
Actually, I do have a question about that. So one of my comments yesterday, which then I looked more carefully to try to understand because I'm kind of new to this application, was why you can't have head-in parking running along the entirety of the rear. But I understand that actually that cantilever at the rear allows you to back the car back up and then turn, whereas presumably you can't do that. I'm trying to understand why there's parallel parking in one section and not in the other, because you can't do backup.
Well, we've essentially tortured over the parking quite some time, and the architect has tried a host of different configurations. And in each case, because of the interference with either the building or the columns, the cantilever, it was not efficient. And the design you see now is what is a result of all that discussion, all that consideration by the architect.
Because I'm wondering if, for instance, one of the things that's sort of so unfortunate about this is you give those very large side yards, but really they're just driveways. So in the end, you're not really giving anything, and ultimately, it's kind of a shame that that's all it's used for is driveways and parking. And if there was a way to get just those, I think it's 4 spaces, out of there and put them at the rear, that would really improve the aesthetics of this building tremendously.
Well, we could take a look at what
I think it's only 2 spaces.
It's 3 spaces, actually.
3 spaces?
Yeah.
Okay.
I mean, we could take a look at moving that to under the well, I can't do that. Maybe under the cantilever, so that it's not it's on the left side of the yard. It's not really a side yard because you do have the cantilever. So the side yard on that side is only 15 feet, even though at grade level it's wider.
Wide. But the experience from the street is that 32-foot wide parking lot. That's what people will experience, not the 15-foot wide side yard that the residents will experience, the residents who have those apartments. And so from the street, that's dismal. I mean, and particularly because it's not treated in any way. And if you were to get those parking spaces out of there, then you could actually really landscape this. You could provide seating, you could, there's a lot you could do.
I'll have the architect taking a look at it, but we've tried. I don't think there's any way of taking those 3 spaces and moving them to the back and still have enough maneuverability for the other cars. But we'll take a closer look at it, but,
Okay, yeah, if you could do that.
We've done the best, and we can treat the front a little differently by having some street trees and other plantings maybe in the portion that's not a driveway.
Well, would the parking, for instance, work if it was head-in parking on those side yards? And then you wouldn't need such length? I don't know. I don't even really drive a car, so I can't talk about maneuverability.
Well, I've got columns in the way.
No, I know you have columns, but that didn't stop the architect from putting 2 spaces underneath the cantilever where I'm impressed by parking skills getting in there. That's sort of sideways parking.
That's
There
actually...
used to be, Buckminster Fuller invented a car that could park sideways. I think you need one of those.
That would help. Then we could rearrange the parking layout.
Right.
Okay, but I understand where you're coming from, and I don't know that we can do it, but we'll go back to the architect and...
Okay, great,
And then we'll present the landscape plan also,
great.
as well as a facade treatment.
Okay, that's terrific. Okay, are there any other comments, first of all? No? Any speakers on this item? Okay, so if you could, how much time do you think you need to submit that?
We're under a time pressure here. We can get back to you in a week.
You can? Good. Okay, so, is that true? That's the architect you're pointing to?
No.
Should be the architect you're asking this question of.
That's true. That's true.
So let's just say submission on the 9th to make this a real submission. But then that would mean, okay, submission on the 2nd, how about that?
Let me take a look at that just a moment, please. Just indulge me. The 2nd, and we can get back.
And then we could come back on the 16th of December?
Okay, that's fine.
Okay,
That works.
great.
Item number,
Whoops, sorry. That's it. Okay, good to go.
item number 27, 26413BZ, 257 West 17th Street, Manhattan.
Oh, that's it?
Okay, thank you very much.
You want to talk more
I was
about
waiting
other
for the
stuff?
vote.
Here we go.
Good morning, Commissioners. Frank Angelino on behalf of the application. Since our last hearing several weeks ago, we've submitted an update, and that update and that schedule is still in place, and everything that we submitted is still relevant. The work is ready to, the ceiling is ready to be closed in. I think this week they'll be moving sprinkler heads, which is permitted by the Department of Buildings, and then closing in the ceilings. And that's pretty much the status right now.
Okay, great. For me, I'm not sure if it was just a transmission factor, but the photographs of the spring installation were all in black and white. What was that?
They were taken in, because of the late hour of the request, they were taken in black and white, and I have some better images because they were taken by a phone and we couldn't get them duplicated, but I have some better images that I'm going to pass around now if you want to take a look at it, and we can get you better photographs.
Yeah, we're using a flash, just so, actually, this is as much for the owner as it is for us, because there's nothing quite like having paid for a really, really expensive installation, and it turns out they didn't install it. So, yeah.
But I can pass around some images that are clearer than the ones that were transmitted and got blurred by the transmission.
Okay, great,
Okay.
thanks. Are there any other questions about this one? Are there any speakers? Yeah, just give them a second. Okay, we have a speaker.
Good morning, Jay Ginsberg for the condominium. The only reason I'm here is just to follow up. I know the ceiling work is going on. I was wondering if we have any time schedule or update on the floor, which seemed always to be the bigger issue. And I would just like to pose that because I didn't hear anything about it.
Okay, thank you. You want to respond to the question about the flooring and the sequencing?
Sure. Frank Angelino, once again. The ceiling, of course, was identified as the issue by their consultant and at the 2 hearings ago. And then we started doing the ceiling, and as we indicated, that after the ceiling work is going to be completed, we're going to be doing sound testing with both the sound engineer, which is Criterion, and also with Wilson Ehrig, which is the vibration consultant, to make sure that the ceiling is working in the manner in which it's supposed to be working. And then all of the equipment for the floor is in place to start work. And once that sound testing is done, the work on the floor will be done first with a test section, and then moving on as that's tested to make sure that the result of all this is effective. And that's been the schedule from the beginning. So while we're equally concerned with the floor and what results will benefit the rest of the building, first is to complete the ceiling, which, as we've indicated, should take about 2 weeks.
Okay, great. And I just want to, if I understand correctly from the submission that you made, the buildings engineer, sound engineer, actually came to inspect the installation but didn't have any comments? Was that?
I could put, Jared?
Yeah.
Yeah, I wasn't at that meeting, but Jared Perlmutter, who was at that meeting and can speak to it. I can say that we were told that he had some comments, and then through since it's a litigation matter, through Brick's litigation attorney, he twice contacted Mr. Ginsberg for comments, and we've received no comments to date. We've been waiting to close in the ceiling, but we don't want to do that, of course, if there are further comments that have to be incorporated into the ceiling.
Right, okay. Yeah, Mr. Perlmutter, you want to? I don't know if you have anything to add or okay. So just a note to the building, if the engineer doesn't give comments now, and the ceiling is in process, they're going to be closing it up. They've submitted lots of documentation to us. And yeah, do you want to come up? the building, I mean, Brick has submitted a lot of documentation to us, so we've corrected it, they've corrected it, and if there's no comments from your engineer, we have to assume that their engineer is doing a good job.
I have Jay Ginsburg again for the condominium. I have confirmed with their counsel by email. We're not going to be issuing comment. We're okay with what's been submitted.
Okay, great, okay, thank you. Okay, so this is kind of an ongoing thing, so the prediction is 2 or 3 weeks to close, does that sound right?
That's
So-
correct. Even with New York construction, I think that that's a safe bet.
Yeah, okay. So if you could come back here in, say, 3 weeks to give us an update, and also, just as an ongoing process, just send us photographs of status so that we know from week to week how things are going.
Mhm.
That would be great, because that way we know you're still working, and, you know, people didn't take off 3 weeks because it's Thanksgiving or something like that, okay?
We can do that.
Okay, so come back then on the 9th of December?
The 9th?
Yeah. And submit on the 2nd, another series of progress photos and a statement about what you're doing, and maybe by then you'll even have closed your ceiling and you might have started your testing. That's optimistically.
If we have, we'll give you a report.
Okay.
Okay.
Great, thank you very much. And actually,
Thank
I
you.
want to say, I do really appreciate the owners, the Brick owners' cooperation in this and really trying to solve this problem.
Yeah, well, we appreciate that. And with all construction jobs, you are aware that there's always extra steps that have to be taken, and the job has been fully permitted. There was, we needed to get an asbestos report. We got that. We needed to get approval for all of the relocation of all of the services, the lights, the fans, the sprinklers. All of those were gotten. And I think that under the circumstances, the contractor has moved as rapidly as could be expected.
I agree. Yeah.
Thank you.
Thank you.
Item number 28, 27113BZ, 129 Norfolk Street, Brooklyn.
Hi, Eric Blatnick. You can, if you want to, just grab a seat. I'll call you up. Oh, you'll call me up. Yeah, I'll call you up. I didn't realize it. Hi, Eric Blatnick. Bear with us because we do have, and I apologize, Ms. Matias, we have a few different attachments and they are not collated. I know that that
Need
is
to hire a
already.
collator.
Well, no, they're not collated for a reason. I mean, there's a lot of different, we have a pretty good collator who's out last
I
week.
charge
but-
by the page, Mr.
I know you
Palatnik.
do. I know you do. All right, so the reason we have all this paperwork, and which I'll outline first, and then we could start discussing, is because I reviewed your review session yesterday, and I spoke with my office who was here, and I saw a very spirited discussion amongst board members on this house, and it might have been also referencing over to
To Oxford.
the other house, which is, for the record, 3814BZ at 116 Oxford Street, which I'm representing both of them. And I think the first issue, which I want to just get right to, and Commissioner Hinkson, I know you have the 4'3" issue of the side yard. Unfortunately, we don't have the answer for you today, but we're going to try and get it for you and explain how this freak of nature occurred with it being the same dimension at each end. So your suspense is going to have to wait. But the rest of them, I think we have some pretty good points to raise with the board.
But could you just start, because the threshold question really
Yes.
is, are you demolishing? Or
That's where
are
I'm
you
going.
lifting? Okay, good.
That's right. That's right where I'm going. Ben Leonardi is here today. He's the project architect, and Ben, with his partner Joel Mealy, put together this letter dated November 17th, which I'm going to pass up to you. It's just not collated. Sorry, Tony. And Ben put together this letter, and I just gave you my only copy, so I don't even know the exact wording of what it says. I'll take one back.
Here.
But the essence, which he's going to testify to, is that they are putting their seal and signature on a design method of this building that does comply with the Department of Buildings definition of an alteration, and which does clearly can be accomplished physically in reality. And I know that you're skeptical of this, And I know that you've raised this other discussion point of which I appreciate, which is almost one of an argument of an impossibility, demolition by regulation, which may give us another alternative by which, and I appreciate you looking at it with the flexibility of different ways to solve the problem. This problem that you're confronting dawned on me the moment I woke up after Sandy that morning. The former director will tell you I called him and said, we have a problem because we have a conflict here now. But I think that the conflict has been addressed. I think it's been a time tested since the storm, and even before the storm, unrelated to the storm. It's been that some of the houses have been raised, and the methodology which they've employed is reflected in this letter from Mr. Mealy. Now, another attachment, sorry, Ms. Matias, if I could just find. This one is colored.
Okay. Top one? Top one?
The letter you're reading right now is a very similar letter to a letter for another project which Mr. Mealy did nearly 2 years ago, or a year and a half ago, which is coming around to you. And it's giving the almost exact same explanation. Not only is it giving the exact same explanation, at the end of it, and it's not to tell you that you're wrong in your thinking, and I don't mean to insult you by calling out another resolution, but that's what I'm doing. And at the end of this April 9th, 2012 Mealy letter, which he gave to the board during the course of a hearing on a similar issue, the board issued a resolution, 17611BZ, for that property, which happened to have been, for the record, if I could find the address here, 150 Norfolk Street. And on the very last page of that April, I underlined the applicable language, and the board had the same concerns that you had, Madam Chair. The previous board they had the exact same concern. How could this possibly be? How could you be raising this building? How could it be an alteration? And we gave them this very thorough response by Joel Mealy, who's a very respected father. Actually used to sit on the board. Father was a commissioner on the board, and his father was a commissioner at Department of Buildings, and father was commissioner at DEP, and unfortunately recently passed away a year and a half or so ago. So you're dealing with a well-experienced local architect with years of experience at the New York City Department of Buildings, growing up in the family with it. He couldn't be here today. He sent his best partner, Ben Leonardi, to discuss it further. But what they're trying to implore upon the board is that this is not a sham. The raising of the home and the maintenance of it is a physical possibility. It can be done. It has been done. It's been done, and it's been accepted by previous boards. It's been accepted by the Department of Buildings.
Right, and I don't think actually wasn't about a sham. It was more like, is this the best thing to be doing with these little houses? You know, is it best to, do you really want to be lifting up, what is it, it's a block wall construction, is that what?
No, we don't want to.
Right. So the whole idea is that in the case of buildings that are being lifted, maybe there's a better argument that you can make that's based on BSA precedent and case law that doesn't require the engineer to go to such extraordinary lengths to preserve something that's maybe not the best structure.
I know you're a young woman, so you haven't been doing. There's no way you could be doing this as long as I've been doing this. But when I first started doing this, and the special permits came up, this was a well-cited problem and a discussion about the alteration, and that you're maintaining substandard conditions, and that the practitioners, myself amongst them, have been strong advocates for your point exactly. My concern with going down the road that you're opening for us is simply that once the home is demolished, the homeowner loses the benefit, theoretically, came up in the discussion yesterday. Well, once the home is demolished, they can move the yards in, it won't matter anymore. And that's my concern as a lawyer representing the property owner, is that the advantage to these special permits, I know that I've heard the way you're speaking about them. I don't know if you view them with the same admiration that I do, and to see what they've done for these neighborhoods, and the way I've watched them in the last 17 years, these neighborhoods rejuvenate themselves from these beach bungalows in the old days to families that have moved here from other countries and have established themselves and have really regenerated all of this particular community in Sheepshead Bay and that whole area. But independent of that, I think that eliminating the ability for these people to maintain the side yards, which is a very important part of the special permit, would force these houses to shrink in And I think that they're so small already, and they're so constrained for space. And now the elimination of any sort of cellar space in these homes under the Sandy flood regulations, which I've spoken to the board about before, and how important playing games with the kids in the basement is for a homeowner, and how important the cellar space is for a homeowner for all sorts of different reasons: mechanicals, recreation space, storage space, a host of different very valuable and important reasons to a homeowner, which probably drive a homeowner to even purchase a home in the first instance. I saw an ad in the paper the other day. It was an ad in one of these storage spaces. They have this thing where a box comes to you now, and in the city, and it'll take your stuff, and you can ship it out. You don't have to go to a storage space anymore. And the argument was, for those of you who don't live in the burbs and don't have a basement. And that was the ad. So I think that the space is incredibly important, and we don't want to go down the road just yet, necessarily ad hoc with the board, of eliminating this requirement that you maintain the walls. I think that should be vetted out in a legislative process with all the agencies involved, the Department of Buildings involved. And that's why I'm not jumping on as much as I want to, and I appreciate the opening that you're giving us with this impossibility by regulation. And I appreciate how that works. I mean, I've had cases that have been acting on the board, 3496 Bedford Avenue, which after the board approved it, the walls came down and there was a termite problem. So we've had this before, and I've seen it at Department of Buildings. So I do appreciate it, but in all those cases, you're not talking about the loss of something that the special permit is specifically trying to acquire, which is the width of the homes, and that's my concern simply. But having said that, Ben is here, and he could speak to you more about maintaining the home in a safe fashion. And again, I do respect tremendously, and I'd encourage us practitioners and the board to have a bigger conversation with other agencies about the alteration versus new building, the maintenance of horrific conditions. These buildings are 100 years old, so there's no reason to save them if we don't have to.
Okay, but so if you are kind of maintaining that idea that it's you're maintaining floor area, then, because that's the definition of the existing building, right? So you have to maintain 25% floor area, right? Then I guess I'd like the architect to speak to this, but now what you've got is somehow you are in fact lifting both the joists and both sidewalls up so that the floor area is maintained, right?
I'm going to nod my head unknowingly and speak to Mr. Leonardi,
Yeah,
and he'll be able to explain that. Why don't we let him come up so you can have a more intelligent conversation with him on this issue.
Good morning. Hi, I'm Ben Leonardi, I'm registered architect, Joel Mealy's partner. We are not I think the concept of raising the building is maybe not the appropriate concept. We're raising the floor of the building. The walls are staying where they are. So in essence, if the floor is 2 feet above grade, we are taking that floor and the walls maintained, saying they're 8, 9 feet high, raising the floor, increasing the height of the exterior walls slightly to compensate for the loss, and putting the new beams on top of the existing walls. So the walls are not being raised. The walls are staying exactly where they are. And that, under the concept with the Department of Buildings, is very important, because when we file at the Department of Buildings, one of the things they scrutinize is, are you doing a real alteration or are you doing a new building? And they actually, we're forced to do a calculation for them to show them that the perimeter walls that we're leaving is more than 50% of the walls we're removing of the outside of the building. Otherwise, they will reject it as an alteration. Now, for us to come to the Board of Standards and Appeals and to file something without being, I don't want to use the word certain, but relatively certain that they're going to treat it as an alteration would be crazy for both us and for our client. We would spend a lot of time here, a lot of expense here, going back to the building department, doing our working drawings, and suddenly the plan examiner states, you don't have an alteration, you have a new building. We would look very, awkward at that position. So we are, like I said, I don't want to say certain, nothing's ever certain in life, but relatively certain that this is a true alteration under the guidelines of the Department of Buildings.
Okay, so if you're maintaining the existing walls to the extent you are on that drawing,
yes,
then how does that comply with the floodplain regulations about breakaway panels?
Well, then what we do is we cut holes in the walls. And keep in mind, we are also extending the building.
Right.
If you look at the floor plan, you'll see there are areas where the walls are white and there are areas where they're hatched. The hatched walls are new walls.
Right.
The white walls are existing walls. So there'll be areas where we'll actually be cutting holes in the walls to put the vents so that we have the flood venting going through the building. In addition, since there was a small crawl space, we are obligated to fill in the crawl space to grade, put a new slab at that point, and then from that slab up to the first floor is what we call the ground floor, which is not an occupiable space. It's only used for storage and parking, and our building starts at the floodplain level.
But don't you have to put breakaway panels in the existing wall as well?
Well, yeah, but we can
Yeah,
cut
you
those
do.
panels. We can
Okay.
cut, there's a calculation we must do based on the volume of the space to create X amount of breakaway walls. And that would be, it's not, in essence, breakaway walls, they're flood vents, actually.
Okay.
So we put the flood vents around the building, and that compensates for when water comes into the building and then leaves. In addition, we must be at grade. We cannot be below grade with our floor slab. So we actually have to do some filling to bring the slab up to grade.
Okay, okay. Commissioner Montanez, did you have questions about this, or?
No, it makes sense to me.
Okay, sort of what you guessed, actually.
Yes.
Yeah.
I didn't think they were actually, I think the idea of physically lifting those
No.
foundation walls was
No,
not.
I agree. That
what
would
they
be
meant.
very
It's a-
difficult.
It's a poor word of the use of.
I think that was it, the
word
concept of lifting as opposed to raising the floor itself.
Yeah, okay. Or changing the elevation of the first floor
First
to
floor,
be
yes.
X feet above. Right, okay. Okay,
Okay.
that makes sense.
Thank you.
Stick around, though, you're not done.
An interesting discussion about this whole strange.
Sometimes the architects have to come in, it can't always be the attorneys and the representatives.
You know.
Very helpful.
Yeah, it's very helpful, so.
Yeah, architects don't come here often enough. I don't really understand that.
Eric Latnick again. The next question the board had, excuse me for 1 second. The next deeper question, and I'm starting with the deep questions and backing into the more simplistic questions. The next philosophical question I think that I saw the board grapple with yesterday is the heights of these homes. And I saw another very spirited discussion between board members yesterday about how to determine the character of the neighborhood. And to paraphrase Madam Chair, I believe, and correct me if I'm wrong, or maybe you should say it yourself, but the concern was essentially that these homes are 35 feet and 3 stories for the ones that are, but now they're basically 4 stories now in a neighborhood. I think your exact line was a neighborhood of predominantly 2-story homes. And that you don't want to be responsible for causing a blight on the neighborhood through the board's actions. And when I heard that, and it really, at that point, I decided I wasn't going to bed for another hour and a half last night. And I ended up going up and down Google Street View of all of Manhattan Beach, every single block. I didn't miss a block. And what I saw was that the vast majority of all of the new construction in the area is 3 stories. Most of the families that are building new homes, most of the applications that are coming through the board are for 3-story homes. And I know that Madam Chair thinks you commented yesterday maybe that it's just kind of a 2-story neighborhood, the 3 stories kind of pushing, now you're 4 stories. And now it's all getting all mashugana, we started at this legal term for crazy. We started at 2 stories, now we're at 4 stories. So I remember there was a breakfast a couple of months ago at the Zoning Advisory Council, and this conversation came up because I think, Madam Chair, your points on this have been made well clear from the day you started with this position. And, of course, you have all of us talking out there in the zoning community about this because you have many homeowners who are anxious to build their family homes here. And what you're viewing as a contamination in the community by act of the board, they're viewing as the future for their families and their children. And they're conflicting head-on. So I said there was no way after the storm that this could have occurred, this height issue, that this wasn't thought about by the planners. I couldn't have been the only guy that woke up, or woman that woke up the morning after Sandy and said this is going to be a problem. And sure enough, the City Planning Commission acted on it in September of 2013. And
Acted on what?
they acted on the raising of homes.
Right.
And they discussed particularly the conundrum that you're having. Exactly. I can imagine how the conversation went. Some people in the room said, what are you going to do? These buildings are going to be 40 feet tall. They're going to totally disrupt the character of the neighborhood. And other people said, what are you going to do? We have to protect the neighborhood. I don't know what we're going to do. What should we do? And they took a vote. And it's all right here. I'm not making this nonsense up. I mean, it is nonsense, but I'm not making it up. And you go right to the circled parts of what I'm passing up here. The first circled line I have on page 2 of their intent, of their report, talking about raising the buildings 10 feet higher, which is what Madam Chair is not so thrilled with that we're doing. This will enable property owners today to plan and build to likely future standards. And that term is going to become the phrase that I'm going to be talking about for the rest of the conversation on this issue, and it's the phrase that was brought up yesterday with Commissioner Otley Brown, was very vocal on the point, that this is the future. And I've said this at earlier hearings, and Madam Chair, you know it as well as I know it. You're in a waterfront community also. The height is big, and you're concerned that you're putting the blight by giving us the floor area in order to fill the envelope. That's not true. The heights of the homes would be the same regardless if they had the special permit available to them or not. And what the legislators said, and if you keep reading, I'll just quote some salient language, the next page, page 6. This would enable building owners to elevate to the new standards while maintaining the same allowable building envelope. So they're telling people, when the one person in the room said, what are you going to do? You're going to take away all their space. My Palatnik's going to complain. They're not going to have any space. I'm going to get a call from Palatnik. They immediately said, we want them to have the same allowable building envelope, this same 35-foot building envelope that's allowed to occur today as of right and with a special permit. They don't make a distinction, but they do later, and I'm going to get back to that because they gave an out to the board when there might even be a conflict that you're concerned about. And they allowed them, they're telling the public and the citizenry, don't worry, you can raise your houses if you live in a waterfront community, and all the rights, benefits that you had before the storm are still going to apply to you. And you got to imagine they knew this, in Community Board 15, the special permit was in effect because there's city planning. And they didn't say, except for the special permits, those houses can't get it. And why would a special permit be denied the same right that an as-of-right person was? And the whole intent of the special permit was to encourage people to enlarge their homes. But now, by telling people that they have to bring the homes down and eliminate what you said yesterday's third-floor attic space, which is not really utilized, that's not the case. I could deliver to you case after case after case, including one that's on at 116 Oxford after this that has bedrooms upstairs, a whole floor of living space for an entire family. So although the board says, oh, cut it back, it'll reduce the mass of it, now I'm telling that little girl again that you can't have a bedroom. And your bedroom has to be made smaller, and your brother's has to be made smaller, because the mass doesn't fit what the board didn't like. But I'm suggesting that that's not what city planning was going to. And if you go on in their report, to the minimum extent necessary to comply with flood-resilient construction standards of Appendix G, this will make possible the resolution, now they're talking about a special permit on page 14. It'll make possible the resolution of other potential conflicts between zoning and building code that have not been addressed in the text amendment. So what they're saying then, I'm going to pass this up to you now.
We have this one. No? No, you're reading something else. Okay.
Oh, you had me working last night.
It was a good feeling, wasn't it?
Yeah, it feels good to be a lawyer sometimes and not just talk about fencing. The concern that you're raising was addressed in the page 14 of their report, where they said that the BSA special permit will make possible the resolution of other potential conflicts between zoning and building code that have not been addressed. And again, they actually wrote a resolution that says you have the power to raise the height of these homes. You. And they did all of this based around that key language that I said at the beginning, planning to future planning standards. And that's where I'm all, with all sincere respect and no desire to argue with Madam Chair whatsoever, I disagree with your position on this strenuously. Because you are forcing these homes that would otherwise, I think, that you'd be perfectly thrilled with if Sandy never occurred, and you would have no problem with, I don't think, at the 35-foot height, because the as-of-rights can go to 35, I think it's this 10-foot. What we've heard at this review session yesterday, and what I've heard before, is it's this extra 10 feet that from the Sandy regulations that are disturbing you and forcing you to feel that you're causing a blight on the community. So I paraphrased you a lot. I'll shut up at this point and go on in a moment.
Now let me paraphrase me. So
Right, exactly.
It's different, okay. So it isn't about floor area. I'm not focusing on floor area at all, and I'm focusing on neighborhood character as we see it today. I'm not projecting future neighborhood character because that's actually not what the task of the BSA is with these special permits, it's to look at what does neighborhood character look like today, and is the requested modification of the rules or variation on the rules going to negatively impact neighborhood character. So the reason to ask for all of those streetscapes that we've started to ask for, right, is to understand on this block, what's the character of this block, both sides of the street. Because it's true, a few blocks away, there's probably a 3-story house and this. But what I note from the streetscape that Urban Cartographics provided, there are only 2 houses on this streetscape that are 3 stories, and both of them apparently are illegal construction, so as I'm being told. So according to this streetscape, a 4-story, effective 4-story house is not something that fits within neighborhood character. And the reason that I'm saying neighborhood character as of today is what counts is, for one, speaking as someone who used to appear before this agency all the time, not as often as you apparently, but yeah. I often made presentations where I would say, but it's an R5 zoning, or let's say it's an R7 zoning district. Height factor regulations apply here. And so that property right next door could be assembled into a site, 100 by 100, and you could build a tower here and all of that. Why are you making me stay below the level of, say, 100 feet or 80 feet or something like that? And the response from the board consistently was, it doesn't matter what can happen in the future. We're looking at today's neighborhood character. And to sort of reinforce that, because I never understood that myself, I always thought you should be looking at what could be built in the future, what's allowed as of right. I have a series of letters that you may have read because you've been working on these kinds of applications for a lot longer than I have. One of which comes from Joe Rose to James Chin, the chair at the time in 1999. And it starts off as the authors of this zoning provision, which was adopted less than 2 years ago. So just to set that off. So this is written by the drafters, okay? And it's talking about construction on a vacant lot. But so that's not relevant in this case. But it says, though, that even assuming that the vacant lot were not an issue here, the commission believes that the proposed new structure is not appropriate at this location for several reasons. Although the proposed house meets the height regulations of the R2 district, it will be nearly 12 feet higher than all other houses on the block, 39 foot 10 in height as compared to 28 feet in height. And so that's a height factor district where sure enough you could go higher than 39 feet if you have a large enough lot, right? But the neighborhood is characterized by 28 feet in height. And then there are other ones. The width of the building is much wider, the side yards are much narrower. All of the things that are being proposed are not inconsistent.
I'm not sure, sorry to interrupt you. What is this in relation to, though? This is the proposed text at the time, or this is?
No, this was in relation to a particular application, 1347 East 23rd Street, 3699 BZ. I guess the board had asked the commission to opine on development of a particular project on what was ultimately a vacant lot. But there are several letters, many subsequent to that, where all of them looking at the context in the neighborhood as the neighborhood appears today, not as it could appear in the future. And from my perspective, really, a lot of this has to do, I have to say, because I'm happy the architect's here, that it has to do more with the architecture than it has to do with whether it's 1 FAR or 1.2 FAR or whatever it is. It's really about the architecture and its sensitivity towards the scale of the neighborhood. And the focus on the attic is because, for one, the attic, as shown, has a very large mechanical area. If in fact it's all mechanical, then it doesn't need to be as prominent as it is. And for two, we've seen other houses designed where, in this case, for one, the drawings are not consistent, so that was part of the confusion, right? So the axonometric shows a single shed attic roof behind the bedroom raised roof.
Yeah, in this case, they were able to bring it down, and Ben will clarify for you which plan is correct.
So that's part of the problem, because the only thing that's really showing about bringing it down is the axonometric, and none of the elevations or sections are consistent with that axon. And I think that actually the axon is showing the peak of that portion much lower than the elevation shows it. So I think a lot of it is doing disservice to itself because the drawings are not accurate. But the other part of it is you have a front peak, and then you turn that, and so there's this shed that makes the elevation very, very high. But sometimes we see applications where the project just has the peak sort of ascending at the back very subtly, and the result of that is the appearance on the street is not as huge. Or you have small dormers that provide the head height without providing all of that mass at the roof. So what we're really talking about is a design modification. We're not talking about a floor area modification. It's not like the end of the brother's bedroom as we know it and things like that. We're talking about a more subtle treatment of the attic where you're lifting the house up, where you do have to acknowledge that nobody else has a 4-story house yet. And if you were to come back with this in, say, 6 years, where some people, as you know, some people will lift their houses and some won't, right? Depending on their relationship with their flood insurance and whether it's a new purchase or new construction. So actually, the neighborhood is going to be all over the place. And so what happens on this street is unknown. This street may only have a couple of houses raised, right? So that's to paraphrase.
Okay, if I want, Ben, do you want to speak? I think Ben can speak, because I know that, and to clarify, that if the height is, as you propose suggest on the axiometric, which I think Ben is going to confirm, does that meet with the board's satisfaction on this application?
You can't tell, it's not dimensioned, for one, and it's not shown on elevation, so we don't really know how it plays out, you know what I mean?
Yeah, well, I'll have the staff correct that. But getting back, you mentioned the large mechanical space in the attic. And the reason for the large mechanical space in the attic is the first floor, as I stated before, can only be used for storage and parking. So we cannot put a boiler, we cannot put air conditioning units, and we're sensitive of putting air conditioning in the yard because we have another flood like Sandy, they'll lose their air conditioning.
Right.
So any and all mechanical really has to be somewhere above the floodplain. And since we have limited floor area on the other floors for livable uses, we put it in the attic. So that was one of the reasons why the attic is a little bit larger than, normal.
But you don't need the kind of head height that you do in a mechanical space.
Well,
you do for a
the
bedroom.
client wished that he can go up there and maintain it and whatever, but that,
Well,
I
he's
mean,
not
we
gonna
can talk
dance
to him.
there.
Like I said,
Just a boiler, right?
unfortunately, Joe Mealy was dealing with this project. I stepped in at 4:30 yesterday afternoon when he called. And I wanted to, come just so I can voice whatever I can about
Like
it.
my hot water heater's underneath the staircase.
But the problem is, we cannot put anything of a mechanical nature on that lower level. As far as also the height, keep in mind, if developers went through that neighborhood, and this site is only 25 feet wide, but let's say hypothetically, they were to build a house on a 25-foot lot, or they would take 2 lots and build a house, all these houses could be the identical height that we have here because it complies with the regulations of the building code without going to the Board of Standards and Appeals. We're at the board because of the floor area issue and things of that nature. But the height factor is really, in my opinion, although I am sensitive as an architect to an architect about relationships of spaces, the height factor, we may go down that block 6 months from today and see 4 or 5 houses, 35 feet high, 4 stories, and when I say 35 feet high, I mean above the floodplain.
Right.
So, character is also, there is an aesthetic character, but we should also keep in mind the character of a neighborhood where the people live. We do not want to change the ability for people to live in a neighborhood. And I've come across this quite often where a couple buys a home, and it's a small home, and they come into my office and say, I want to add 1 or 2 bedrooms, and the zoning doesn't permit it. And, well, you got to go to the Board of Standards and Appeals. It's an expensive, long procedure. And what happens is they end up moving out of that neighborhood. So character of a neighborhood is not only the aesthetics of the facade of a building, it's the people living in the neighborhood. We don't want to change the community as far as having, people live with their children and growing up in a community. And that is one of the things I'd just like to emphasize about character also.
But playing around with roof elevations and splays of peaks does not affect the ability of a family to stay someplace, right? That's all we're
Well,
talking
except,
about.
like I said, for floor area issues, it does. And like I said, if we do not have an ample amount of space in the attic to put the air conditioning and the boilers, that only means we have to put it on the lower levels, and we have limited floor area there, too. So
But you could
it's really-
possibly, toy with the idea of reorienting the ridge.
Well, that, I will, like I said, I didn't work on that part of the project. My partner did. I was called here at the last minute, and I wanted to come to the board to discuss whatever I can. I will discuss it with him, and I'll also discuss it with the client, okay? And I'll do the best I can as far as that goes.
Right, okay.
That ridge height is awfully high for just a mechanical space. In your section, you're showing you've got an 8-foot clear from your floor
The
joist.
concept was that he wanted to be able to get up there and not,
But you've got 8-foot clear to the bottom of your roof rafter. And then you got another 4 feet between the roof rafter and the
You could
apex of your
begin
roof.
your rise much lower.
You got
could
12 feet
spring
to play
lower.
with.
unfortunately, I can't answer to that because
Yeah,
I don't
yeah.
know what the discussions were on.
Right. Or you could have dormers, I don't know.
Yeah, it can come down.
Okay.
Eric Palatnik. We understand and will address the plans to reflect the design that we just spoke about. This application is a little bit easier for us to go along with the whole discussion, just because it is mechanical space. So we will amend that, and we'll resubmit it to the board. I did just want to add, because I just can't, it doesn't sway, Madam Chair, at all, the sentence on page 5 of the city planning report, that it will enable property owners today to plan and build to likely future standards. That doesn't sway it?
For one, this refers to a different special permit, right? Which
Well, this
actually
refers to the
just-
entire resiliency text.
Yes, okay, but so it's a resiliency text, and there's a special permit to accommodate for it, but I should just say that I have been talking to city planning, and I know what their thinking is, and they do feel that our job here is neighborhood character. Their job there is resiliency. So, and resiliency, and when they do rezonings, they're determining what the neighborhood character is with the rezoning, but on a literally spot-by-spot basis, when you issue a special approval at the BSA and at city planning, they're looking at neighborhood character as it is today. So when they look at, when they look at a little zoning of a corner, they are looking at what's that going to do to the neighborhood as it is today, right? Not as it is in the future. And then they realize that that rezoning is potentially going to do something very major to the neighborhood, but I doubt city planning had any idea what this special permit was going to do to these neighborhoods.
Well, the text really just wasn't for the special permit, it was for the entire resiliency
Right.
chapter, and it was, we disagree. I was just I think it really confirms that the city is trying to protect the citizenry that lives in the flood-prone communities,
Absolutely.
and trying to incentivize them not to abandon their homes and to go develop elsewhere.
But again, you're seeing a conflict between, okay, it's okay to raise, what we're talking about here is go ahead and raise it because you should, because you must, actually. And you're seeing that as a conflict with simply wanting to modify the shape of roof design, and I don't see the conflict. I just see that as creating better architecture.
Fair enough, fair enough. Well, thank you for giving us the time for the discussion. We appreciate it. It gives us a little more insight into what we're doing. I appreciate it.
You too. Thank you. Okay, so anybody
have another
else? Any
issue.
other comment? Yeah.
Oh, wait,
You
yes.
had more issues,
I'm
yeah.
sorry, you did have
Oh,
more
yes,
issues. I almost
sorry,
forgot.
fire department. Oh, my gosh.
Oh, you almost forgot to
Okay,
raise
actually, we
the
do
fire
need-
department issue.
We need the
Right,
fire department actually to come up and speak to us because that was a question raised in discussion about.
Yes, I'll let them
So
come up and speak, and then we'll...
Good morning, Madam Chair. Good afternoon, Madam Chair, Commissioners. Let me say this. Traditionally, the fire department does not comment on single-family homes, whether they be enlargements, new construction, or whatever, unless invited to make a comment. And the reason for that is pretty simple. We are, other than the obvious things in terms of access, which is specific in the fire code, GCL cases 35 and 36, the fire department really is limited legally in terms of enforcement of the administrative codes when it comes to single-family construction. Very limited in building code enforcement. We can certainly enforce the entire multiple dwelling law, but that's the multiple dwelling law. With that said, when we are invited to, and this is certainly trying to address Commissioner Otley Brown's concerns, when we are invited to review a potential design or review a design, we are going to take the conservative position. Now, in this case, we're looking at the design and saying that there is an existing side yard, there is existing access to, in this particular case, 3 sides of a building. Based on the board's request, we were asked to comment on the design as it stands. And the design as it stands is restrictive to us in terms of having to respond to an emergency situation. The porch, because of the building being raised, is a stairway up, a raised porch, and then a stairway back down. And if that barrier certainly would affect the fire department response in an emergency situation. Now, we are not against the design, and we certainly could work around it, but again, when asked to comment, we review it not from a zoning standpoint and not from even a code compliance standpoint. We review it very simply based on, given this particular scenario, what are the boundaries, barriers, or concerns that we would have in responding to this particular location. Therefore, the comment that I made was pretty specific in that we would recommend that a design be considered where open side yard is preserved, simply for ease of access.
I just have a question about that. So your concern is then what, firefighters have a lot of equipment running up and down the stairs?
I mean, this particular property, as well as connected buildings, townhouse-type construction, it's a pretty silly statement when you look at what I wrote. We do access from the front, and we do attack from the front, and there's no question that we attack from the front. But what I'm looking at here is that here's an existing condition where I have the benefit of having access at the sides, and I have the benefit of uninterrupted and unrestricted access to the rear of the property. You're asking me about a potential design, and I'm telling you I would prefer that a side yard be maintained. And that's it. That's the statement, is that simple. And basically, if we're 2 cases away, but there's a related case that Mr. Polaknik will be bringing to you in a few minutes, there's a side yard. Now, that statement, you're going to ask me if I have concerns. My concern is I would prefer to have 36 inches. I only have 34 or 35 inches. But I have a side yard and I have access there. So the restriction or the concern of the fire department is I don't have 3 feet. Now, that's pretty silly, but, effectively, that's pretty much what we have there. So in this particular case, if we have the ability to modify the design prior to construction, the fire department would recommend that something be considered where unrestricted access along the side of the building be provided. That down stairway, again, it comes up to a porch and then back down again. In effect, there's a wall.
Yes.
I have no way to get to the rear of the building, and on the other side, the lot line, we're built to the lot line. So that was our concern.
Right.
If perhaps the design might simply change by making some sort of a legal but narrower rear stairway to the back, so that we can at least get some kind of access to the rear yard directly at ground level. Keep in mind, the building is going to be raised, but we're working from ground level up, and we would prefer not to have to climb up and then climb down with equipment in terms of access in the building. So ultimately, the design is fine in terms of, if presented with that, the fire department would be able to access the building, but being that it's simply on paper at this point, I would prefer it be a little easier. And that's the statement. Hopefully, I've simplified the position of the fire department, and I've, calmed down a lot of the concerns that the applicant had in terms of us attacking his design.
Okay. Thank you. Thank you.
Any questions?
No, I don't.
Thank you.
I don't think so. Thank you.
Once again, Ben Leonardi. I have a lot of respect for the fire department. I mean, safety, I'm always fearful when I hear about a fire. I say, I hope it's not one of the buildings I designed. However, in this particular case, I don't think it's really logical what's being presented. You can always make something safer. You can sprinkle a building, you can put a fire alarm in a building, anything can always be made safer. But this particular house has more than most houses have. Most houses in the city of New York are row houses, which means you can only enter from the front. We have a side yard. We have a side yard where there is ability to get to the rear yard. So I think we're giving more than is normally given on projects. The answer was, can we redesign it to come in at the lower level? Well, if we redesign it to come in at the lower level or put a stoop in the front, once again, we're talking about differences in architecture and entering at the lower level. Once again, you're entering through that storage, quote, garage space. I don't think it's, the right way to approach it. So as I said, I think we're giving more than is normally given in the city of New York. If this was an R5 zone and I was designing 6 row houses, every house would be in violation of the intent of what the gentleman has presented. So I respect what the fire department says, but I think it's not appropriate in this case.
Okay.
Thank you.
Any questions for the architect?
And just to say that also, it's also a function of having to comply with the floodplain. If, for instance, your floodplain was down at grade.
Right.
You would have no issue with having, an at-grade access in that side yard. But since your base plane has now been elevated, it would be virtually impossible to have an entry into your first floor without.
Well, I don't want to use the word impossible. I mean, it is possible. It's just not as desirable.
But it may not be desirable, but in some cases, it may be virtually impossible.
Yeah, it could be, yes.
On another level. So as we see more of these types of situations, the fire department may have to be thinking that their side yard access could be in some ways impaired by having to have stairs in that side yard just simply because your base plane has been raised.
And also, in this particular case, if you look at the plan, the steps are at the front, and then there's a long walkway, and then the steps go at the back. So it's not like you're going up steps and down steps. We have a long walkway, so if they're bringing hoses to the back or whatever, it's not like you're running up steps and down steps and dealing with it. You're at a platform that runs approximately 30 feet long. So I think we have a bonus here in having the ability of somewhat of a side yard, and the side yard is 4 foot plus wide, so it's better than having no side yard, is what I'm saying, all right? Which in most cases, is the fact.
And before you leave, I want to say that my 4'3" issue, I think that you explained and sort of cleared that for me in a sense. My impression from your initial submissions was, yes, that you were lifting the building, yes, that you were probably getting rid of a good portion of the foundation wall to lift your building, and in your explanation today, you're not moving that foundation wall.
No.
And you're keeping it at its, I guess, its most widest point.
We were restricted. As a matter of fact, if you look at the other side yard, you can see the building, when it was built, was skewed. At the back, it's, I believe, 1 foot 2 inches off the side lot line, and at the front, it's 11 inches. So we're forced to maintain that footprint. Once we change that footprint, then it raises a flag, are we actually changing the walls of the building? So that was another reason why it was done that way.
Understood.
Thank you.
Okay, thank you. Okay.
Hi, Eric Lennox. Long hearing, but I think it sounds like we addressed a lot. I think if my note-taking is correct, the only outstanding issue that the board would like us to address is lowering the ridge height.
Correct.
So
Yeah,
good,
yeah.
I'm glad we were able to satisfy you. And we'll address that. I think Ben will probably need a couple of weeks to do it, maybe give him until the week after the holiday so he can enjoy his holiday.
Okay. Okay, are there any speakers on this item? Any other comments from here? Okay, so would you say the week after?
Yeah, I think
Does that mean the 2nd, or does that mean the 9th?
the 9th would be
The
better.
9th,
That gives
okay.
everybody a little chance to breathe.
9th of December, but then we wouldn't be able to
That's fine.
be heard until January, okay?
Nobody's breaking ground until the spring. so
Okay, so next hearing on January 6th.
Thank you very much for your time.
Thank you. Thanks for bringing the architect, yay.
Item number 29, 5-14BZ, 1807 East 22nd Street, Brooklyn. It's adjournment.
So, that one was adjourning, right? Okay. Yes, okay, so is Frank here? No. Okay, so I think, sorry, I'm lost on this page. Yeah, okay, sorry. That one, there was a request for an adjournment until the 27th of January, so for a submission on January 13th.
Item number 30, 2514BZ, 1601 Avenue J, Brooklyn.
The applicant also requested an adjournment on that until December 9th for a submission on the 25th.
Item number 31, 3814BZ, 116 Oxford Street, Brooklyn.
Hi, Eric Platnick. Really getting a run for my money on special permits this week, right? Madam Chair, I appreciate the diligence with which you're reviewing the applications, and we did try to document to you with with respect to the multiple rear lot lines in this application. We had thought we would be acceptable under 23-543, but as you went through very specifically when I watched your replay last night, and you're very familiar with this section, and I spoke to my architects, everybody said, huh. After I spoke to them at the beginning, before I made the submission, after I spoke to them after you spoke, they said, well, you might have a point. So you were correct that the 23-543 for zoning lots with multiple lot lines does not apply. You then directed us perhaps to take advantage of the provision that may not require a rear yard within 100 feet of a corner. Unfortunately, though, that doesn't apply to us either. And I have that here. I'll pass that up to you. And I know you were trying to help us with that. But I'll pass that up and.
It's a different one? Okay.
That's just a different one. I just passed up two printouts from the zoning resolution for you. The first one, well, you all get it in your hands first.
Oh, there's two?
There are two. Only two. That's it.
Okay.
Okay, so 23, I'll wait for Commissioner
541.
Montanez to get herself squared away there. Okay. So section 23-541, which is the first page that should have came to you, it's got the section circled. That's what I was just speaking to a moment ago, Madam Chair. Nobody really knows about it. You shouldn't feel that you missed something. It's when I had to talk to 3 different people before somebody finally said, no, they did away with that a few years ago. It used to be within. They did away with the 100-foot requirement. If you look at 23-541 for the lower density districts, anything R6, anything below R6, you don't gain the benefit of having no rear yard.
That's really bad then.
Well, you'd think it's really bad, but then I got lucky, and while I was looking around last night, because I didn't go to sleep, look at section 7369, which is a special permit that your board is empowered with, that allows, in instances where things get a little cockamamie, to allow your board to vary the yard requirement, subject to the provision would adversely affect the layout and development of the site, and that it would be the least amount of space necessary to afford relief. And of course, we could give you more information to support each of those and to flesh those out a little bit further, but at least it gives a remedy.
So you're going to amend the application and include that special permit? Is
We'd
that
like
the
to if
idea?
you're along for the ride.
Okay. I mean, it's crazy lot you've got, you know?
It's a little nuts. The owner who's here today, happens to own the property that it's adjacent to, so I could look for on the lot, but it's one of the rear yards it backs up to it. But we will look at that and present you perhaps with more information to support that finding.
Okay.
That's it for the handouts in particular with respect to the zoning resolution. I do have some more handouts because the next issue that the board raised was again the character and discussing the character of the neighborhood, and it was a concern. With respect to the raising of the building, I'd like to put that discussion on hold because I wasn't able to get that architect to be here today.
Okay.
I would like him to try to put together a discussion for the board on a narrative, as you were just presented with, and then have him attend the next hearing with our office to maybe get you to the same level of comfort that the previous architect was able to. So passing through that issue, you have in your file already the documents that I'm about to pass up, but I thought just for ease of review that I would pass them up to you one more time. I'm going to do this at the same time.
Separate one? It's different from that one?
Yes. I'm passing up both of these are in your files already. I just thought it'd make it easier, so you have everything right here. The reason I passed up the land use study, which is the first document is the land use study, the second one is photographs. The photographs I'm presenting to you because you had discussions about the rear yard yesterday, and they capture the rear yard. But the land use study I'm presenting to you for a different reason, which is the pages aren't numbered, and a former vice chair would kill me for not having them numbered. I will have them numbered in the future. But you start to see the pictures that are within the land use study, about the fourth or fifth page. And there's a series of them. They're numbered 1 through 21. And what we're trying to present to the board here, particularly with respect to photo numbers 2, photos number 1, as well as photos along Oxford Street, is that a lot of the homes that you're seeing here, this goes to the height issue, are 3 stories now. They're built to 3 stories. A lot of newer homes, that's the theory that I'm developing, that a lot of the newer homes are 3 stories. In this case, particularly, the homes to the immediate left of the property, which aren't captured here, I was hoping they would be. There are 2 homes to the immediate left of the property, and those homes are, in fact, of larger size than most. They're 3 stories. And the pictures here, pictures 1 and 2, show pictures to the right of the property along Shore Boulevard that were butting up against their rear yards. And you can see there the homes are 3 stories. So unlike the earlier application, which I kind of didn't want to agree with the chair so much that the streetscape showed that the houses don't really fit in because the 2 houses next door were illegal and our house sort of towered above them was your theory and the architecture could work. And unlike that application where the 3rd floor was not habitable space, this application, 3rd floor, is habitable space. So the redesign, and I know you think just creating a couple of dormers. I live in a house with a dormer in the kid's bedroom right now. I'm just about to put myself through hell to eliminate that because it's unlivable with the dormers. I can't tell you how many times everybody's hitting their heads in the room, and the kids are only 8. As they get older, they're going to hit them more. So the idea here is to base our request to increase the height of the building upon the neighborhood character, which is exactly what you were suggesting before. And to do so, we're suggesting that the homes immediately adjacent to us do fit within that context. And I'd like the ability to expand upon that further. My next submission will include a specific land use study that'll just tailor and zoom right in on the cluster of houses around us on the west side of Oxford Street and on the south side of Shore Boulevard.
I think a lot of it has to do with, a lot of these things have to do with how the projects are rendered.
Right.
So, there's like inconsistencies in the drawings. This is the one where the dormers keep getting bigger, They're sort of like they're not the ever-shrinking dormer, they're the ever-growing dormer, and it's hard to tell what's really going on because one elevation shows the dormers being small, another one shows them big. It's actually hard to understand what's happening. And I don't think in this last submission you had an AXO, did you?
No, it does not include one.
No. So the AXOs are really to understand what's going on with the roof line because the elevations, well, for one, they're not consistent, and for two, the roof plans are often not that clear about where the pitches are, how high they are, et cetera. Yeah, actually, the roof elevation doesn't really look anything like the house.
So perhaps, what I'm understanding is maybe things should be clarified for you a little bit more before you render an opinion necessarily.
Yeah, well, that certainly should be clarified, and then in an attempt to try to bring, again, because the house, I mean, if you just look at that street elevation that you provided with your submission, the building, I think, is somewhat taller. I can't tell by how much taller, because it's the other thing, that there's no information provided, right? So we don't really know what the ridge line is, what the height of the ridge line is, compared to its neighbor.
Understood.
The proportions on this house are much better than on the other house. So
That's encouraging.
So it doesn't, it's not as, for me, it's not as glaringly overwhelming. And maybe it's like little tweaks that bring it down just a little bit so that it's more in line and doesn't tower.
Fair
So
enough.
while the architect's looking at clarifying the drawings, if you could just look at that a little bit, because again, there's huge height above the attic. The attic is shown at 8'2" to the bottom of the structure. And then there's this very large peak. So maybe if the peak display were wider, then you would bring down the height.
Bring
of the
down the
house.
height a little bit. Understood. We'll talk to the architect and see what he could do. Based on our earlier hearing, I have a lot more insight to what you're trying to accomplish, so I'll be able to communicate that. And we will have him at the next hearing with us as well.
Okay, great. All right, what else was there? Oh, yeah, and just to clarify, there's some sort of mechanical thing that's shown on plan, but it makes a strange appearance on the side of the house.
I saw that. I heard you made that comment, and I looked at it. I don't know what that is, and I'll find out for you.
Okay, find out and see if it could be improved upon, because it's it ruins the look of the house.
Understood.
And then, just to clarify about the front yard mitigation, like what they are, the two forms. No. And what else? Okay, I think that's it. So, but you're, in the end, going to have to submit another application for the rear yard.
Yes, so we're going to ask for a little bit of a longer adjournment, and we'll get a new objection for the rear yard.
Okay.
And it singles that out, or see if we can file under the old one. We probably can't file under, I'll talk to council and see if we could file under the old one or not.
And your proposal would be to pull it back 8 feet, as you showed on the drawings?
Yes,
Right? Okay.
yes.
Okay. Okay, so how much time do you think?
If we could submit
It's
this,
a new application, so I guess not sure, we're going to couple, it's kind of a first hearing on the rear yard waiver, coupled with continuation on this one. How do we do that?
I think we'd have to re-notify the neighbors.
Okay, so
we could do a longer adjournment, give the board and us some time to figure out the right way to notify it. Imagine it might have to go back out to community board review as well.
Yeah.
Because it's already appeared before the community board. But if you'd like, we could set a schedule now, and we could submit, and we'll come into accordance with whatever directions we work on with your attorney.
Okay. So how about, just to speed things up from your perspective, if you could submit revisions to the drawings, so maybe the idea was we'd at least be able to look at the drawings to understand the final elevation, so we don't have a lot to do with that. And then, can we do this sequentially, or do we have to couple it?
Might be better to keep them together, I'm thinking.
Yeah, okay.
So, and I'm hesitant to give you the drawings separately, because I usually, when I start digging in on things, find things that,
Okay.
on the second part, that
So
the
do
architect
we
may have
adjourn
missed.
then till the end of January?
Yeah, if we could submit the second week in January, that would be great. That would give us
that's
time.
enough time?
Yeah.
Okay, so a submission on the 13th of January? Does that make sense? Really?
Still has to go to the community board.
Yeah, I don't think that's enough time, right? So,
They get
because let's just
60
say you were
days,
ready
so.
next, I know your office like churns stuff out really fast, but even if you submitted at the beginning of December.
Did I mention the
you're not-
enlargement on the house?
Even if you submitted on the beginning of December, you wouldn't be heard by the community board until January, right?
Yeah, maybe not January or so, but oftentimes what we'll do is we'll hold in abeyance any action should the board act, which the board never would, and I don't think in this instance in January, until the community board acts upon it. So I'd hate to hold off hearings while we wait the community board. It'd be great if we could submit on that schedule we just described a moment ago, and I'll go to the community board while it's in hearings here at the same time. That'll save the homeowner from the back-to-back.
Community board needs 60 days. They get a minimum of 60 days.
Yes, correct.
So even if you still have modifications to make.
Correct.
And then you're going to go to them with this new application. I think we need at least 2 months.
All right, so you want us to submit in early February?
Early February?
That's what we'll
You
do.
submit February 3rd?
Okay, but we're going to be filing before that, though, so that way we get triggered in the community board.
Sure. Yeah.
Okay, great, okay.
Okay.
That's fair enough.
So submit on this on February 3rd, file as soon as you can on the rear yard.
Understood.
Waiver for a hearing then on the, well, ideally it would be a hearing on the 24th where we can couple them by then.
Okay, hopefully it'll work out that way.
So February 24th, the hearing, okay.
Thank you for your consideration.
Item number 32, 9614BZ, 290 Dyckman Street, Manhattan.
Could we just take a short break? Like, maybe even a longer than short break? No. How many more do we have before the 1 o'clock?
You have Dyckman and
two.
Rockaway Avenue, the PCE.
Okay, just 2, okay, just very short.
Super short. Want a 5-minute break, 10 minutes?
5 minutes, that's all.
5 minutes?
I know you've been waiting a long time, so.
Oh, so we take a 5-minute break?
5-minute break and then we take,
Straight through?
then I think we can take a longer break after.
For lunch.
For lunch, because we're technically a 1 o'clock session.
So we won't start again.
It's just so that people, yeah, 1 o'clock.
He was up all night, I think.
Yeah, sorry.
He got worried.
Right.
Okay.
Okay, we're back in the record. Public hearing November 18, 2014. Continued hearing items on the BZ calendar. Item number 32, 9614BZ, 290 Dyckman Street, Manhattan.
Good afternoon, Madam Chair, fellow commissioners. I'm Bob Flahi from Crime 11, representing the applicant on 290 Dyckman Street. I'm joined by my colleague, Paul Selva.
I think he can handle this. Does anybody have any further comments on this? I don't think we had any. Thank you, your submissions were really clear and really addressed the issues, so I think we can close this.
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Decision date?
And decision date?
Oh, decision date. Someday I will get this. Okay, decision date. For the 9th is the next hearing.
December
Thank you.
9th?
December
Okay.
9th, yeah.
Thank you very much.
Item number 33, 13214BZ, 441 Rockaway Avenue, Brooklyn.
Good afternoon, Josh Rhinesmith for the applicant.
Okay. I also don't think we had any more comments on this, so for a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Okay, and we can have decision on this on December 9th.
Great. Thank you very much.
Thank you.
Okay, we're going to recess to 1 o'clock for the new cases for BZ.
Okay.
I'm sorry, I just had to go.
You're on the record still.
Pretty good, although they're ridiculously expensive.
Yeah, but if it's a meal, I feel like it makes it okay. Yeah, redo this application, redo the
Call back 3814, right?
Yes, we're back on the record, and we're going to recall item number 31, 3814 BZ. What are you doing, again? 3814 BZ.
Yeah, 3814. Okay.
This is, sorry, 116 Oxford Street, Brooklyn.
Correct.
Hi, Eric Planican. Thank you for accommodating the request to hear me again. After the hearing, the owner approached me and asked if it would be possible that we could adjourn it for 1 week to allow the board, for him to make his mind up whether he's going to take off a piece of the home or potentially pursue the special permit 7369, I think it was. And for that, he'd asked for 1 week for us to verbally report back to you at the next hearing of our direction and set a either maintain the original calendar, or if he decides to not go that route.
Okay. One thing that I could suggest, so you don't have to rush to your decision, right, is continuing with this application, but just change the drawings to make it compliant to a 20-foot rear yard to the extent it needs to be, right, in that spot, and whatever, right? And then if you choose to go forward with the special permit, then you can amend the drawings at the OB later. You know what I mean? So you could get the determination based on the 20-foot rear yard there, and then at least you have that. And if you choose to leave it that way, that's your business. And
Yeah, but I think that, I don't know if that achieves the end. I think it's just, might be easier to just adjourn it for 1 week, let us tell you, and then go in the same direction. I appreciate that.
Okay, so you just want to come back on the 25th?
Yeah, next week on the 25th.
That's all right. Okay, so we're just going to continue the hearing till the 25th, but there's no submission.
Thank you.
Right, okay.
All righty. Now, new cases zoning calendar. Item number 1, 32113BZ, 3719 104th Street, Queens.
This one we collated. And I apologize to Madam Chair on this application. We had no intent to make you work hard to review the application and understand things. And I saw the tape yesterday. And it's partially my fault because within the statement where I left 2 words out, that there's 6 lots, 35 feet and under, that do not have a building on them. And I did not say that in the statement at the beginning of the sentence, and I apologize. When I was putting things together, I guess the syntax in my head saw it down there, but the words didn't make it down onto the paper.
There's only 6 vacant
Only, right, and
lots.
that's the conclusion of that paragraph that I started off, concludes with that. And it's also, the information came from Mr. Ian Rasmussen's December 12th, 2013 land use study, in which he did the study, and he found that, quote, the area within 400 feet includes 153 lots. Of these, 6, including the site, are 35 feet or less in width and are not improved upon with a building. So what we're trying to show the board, and this obviously got lost in translation due to my omission of the right language, is the uniqueness finding that we're basing everything upon is that the vacant status of the lot at being 35 feet and under, which is 35 feet, we felt was a fairly encompassing size, and that would enable you to develop a structure as of right. That size, there are, of that size properties, with part of it being vacant, there are only 6 that exist that do not have a building on them. So, and of those 6, most of them, as you go through the Rasmussen report, most of those properties are either parking lots that are used in conjunction with adjacent churches or other facilities, and one is actually under construction right now. And he lists them on page 2 of his report, which is not paginated, but he lists the different properties. And so the concept being that there are very few other properties that have this exact condition, which is a relatively narrow lot that's vacant, and that of those relatively few other properties, the 6 were distinguished due to the fact that, as you could see on his page 2, that...
Wait a minute, so that maybe that's a problem. I'm not actually, I see a land use study, the land use study, that maybe
You should have
that's a
2
problem.
land use studies.
The land use study is actually the affidavit of ownership. So that's not right.
Did I label that, or did your office?
I don't know who labels it.
Because hopefully it wasn't the same division in my office that didn't scan correctly.
I think your office labels them, no?
I don't know.
Anyway, I don't find a land use study. I don't know where it would be located. It's not. I only found the land use study addendum, which is the list of the properties, which has the photographs and a list of all the properties. That's part of what makes it so confusing. So you're looking at this map
Okay,
that shows tons of
I
city
understand.
sites.
If I can, I could pass up. I have
Oh,
one copy.
here it is. Maybe it's under a different affidavit. Oh, so they're switched. Okay. The affidavit of ownership is where Ian's work is. Okay. Now I know where to look.
And I apologize, and I understand you didn't have time to digest it because you didn't have the full documents in front of you at the time. But that's the premise of the application. Now, during your review session yesterday, I know, Madam Chair, your first reaction was to say they didn't study the lesser variance scenario.
Well, actually, no, it's more basic than that. So what you didn't talk about was the fact that, so all right, let's just say there's a uniqueness finding because there's only that many vacant lots of that size, right? But the real issue is your problem being that the zoning changed so that you cannot build a 1 or 2 family dwelling on this site unless you have 3,800 square feet. And you can only build, you can build a different building on a site that has a 1,700 square foot lot. You never mention that in your statement of facts. So that's the problem, because when you're reading this, you're saying, well, aren't you creating your own problem? You want a
Right,
three-family
why can't you
house?
build, because I don't call out the fact that you can't do the two-family.
You
And
basically can't do anything.
You can't do anything with the property, and I
Right.
should have made that clear. And as you said so clearly yesterday, and I'll say more clear in my next submission, is that the two-family actually increases the degree of the variation request, because the two-family, you're constrained with your yards, so we would be here for a yard variance. We'd be here for the same issue for the parking, but we'd also be asking for a minimum lot size variance. We'd be adding a third variance to it, because the minimum lot size for the two-family, in the handout I passed out for the other board members, it's the second page, gives you 2332, which is the minimum lot size. And I circled there
Yeah.
on the second page.
3,800 square feet.
Right, 3,800 square feet is what you would need for a single or two-family detached or zero lot line where permitted. And we're in an R5 district. So there's nothing that can be done. That's what's driving the application to the board. I know that you had a lot of discussion yesterday also about it, the density, and it might have been tied into this discussion that we're having just now, but I know that there was a lot of commentary about perhaps us showing that there are a lot of three families in the area, and that the three families really needed. I just wanted, perhaps again, this was called out in the papers in the land use studies, but I could accentuate it more. The three families as of right, it's an R5. It's a contemplated number of dwelling units. And it's not the reason, I know that you had the question yesterday, what was the purpose of the rezoning? It was not the purpose of the rezoning to eliminate the three families. The purpose of the rezoning, I can pass this up to you. We printed up the North Corona rezoning, and it says right on the first page, to protect and reinforce established lower density context. Rezone all or portions of 68 blocks from R5 and R6B to lower density R5 or R5A. It strikes it as me as what they were trying to do is lower the heights of the buildings and try to prevent, they weren't so concerned whether there was two families living in a building or three families living in a building, but rather the heights of the buildings, because it was R6B before, which also allows for, apartment buildings with multiple dwellings within it, same as the R5 does. I'll pass that up for the board.
So, in addition to like revising the whole statement of facts so that you can understand actually what it is you're
Right.
trying to do.
Yes.
You should be talking about, if you were to develop, because that was the other thing, we looked at the drawings for your complying three-family house, and it looks ridiculous because it's only 8 feet wide or something like that. And it almost looks like a joke, right, that you're not taking seriously the application process. But that's because it looked like a joke because you didn't make clear that you can actually.
That there are no other
build nothing.
alternatives, and
Right.
I saw that
Right.
disconnect yesterday with you, and I apologize, again, that's my fault, I could have been
So you should-
much more clear. I took it as a given that nothing else was allowed there. And again, it's.
And if we were to talk about a different way of looking at the variance, if you were to say it was a two-family house, and we were to waive, say, the minimum
Lot size.
lot size, then what would the side yard requirements be there? Would you be able to meet them?
No, that would, and we'll submit that to you. The architect is here with us today, Bill Salem. He could speak to it if you want him to, but it would be, you're required to have an 8 and a 5-foot side yard
I thought it's measured off of the location of the
of the adjoining
buildings.
homes. Buildings still, you have to speak into the microphone, Bill.
I didn't study it carefully, but I thought that's what it was. What? Matt? Yeah.
Good afternoon. My name is Bill Salem. I'm the architect. The minimum, it's not only also the minimum lot area, it's the minimum lot width. So in our case, we have a 25-foot lot. The minimum required is 40. Now, if for a single or two-family detached dwelling, you're required to have 5 and 8, no matter which. It doesn't matter whether it's coming from the side of the adjacent building. In our case, it's from the property lines. So we would have to do a 5-foot side yard and an 8-foot side yard, leaving us with a 16-foot building, I believe it was, when we did the new plot plan, which also turned out to be unfeasible for a two-family home. So there are clearly other issues that we would have to ask you for: the minimum lot area, minimum lot width, and also side yard variances with doing the two-family, as opposed to having the three-family and the parking. Yes.
Okay.
As
So this
opposed to
one
doing a
has
three-family where the lot area and the minimum lot width worked, but the side yards were an issue.
Okay. Okay, so then.
Thank you.
So then, Mr. Palatnik, if you would address that in your statement of findings, even if we were to build a two-family house.
Yes, I'm
this
understanding
would
that,
be-
yes.
I would need this many variances.
As soon as I
Okay.
saw your video
Okay.
yesterday, I
Okay.
understood clearly.
Okay. Any other comments on this?
Yeah, you keep saying that the R6B, you could have a complying building. Could you
Yeah.
give me some drawings that show
To show what an R6B would have allowed?
Right.
Yeah, the R6B doesn't need any, I'm looking at the architect, so you can't speak, but the R6B doesn't require any yards, is that correct?
R6B is required to either have 0 or 8-foot side yard, so we would
But-
be able to build lot line to lot line.
There's no required minimum distance between buildings?
And in R6B, no.
Okay. And then the other question I had was, would it be possible to give me a land use study showing the width of buildings in the area, the typical width of buildings in the area?
Yeah, we'd be happy to. It clearly shows, you'll see that this condition that we're requesting to create is the condition that's prevailing around.
Well, it might be,
the
but
community.
the lots could, you could have 18-foot buildings. Maybe that's the typical size.
Oh, so you're looking for the typical size of a building?
Right, typical width of the
Width
building.
of a building, I thought it was a lot, width of a building,
Yeah.
okay.
Because, this might not be the minimum variance. You could have larger, wider side yards.
Okay, we'd be happy to. And I assume the architect answered your question with respect to R6B, or would you still like to see a plan?
It could be a three-family with lot line to lot line. No requirements for any distance between buildings.
No.
Okay.
Okay, any other comments on this? Okay, and then just because you have the architect here and it's so convenient when the architect is here, and kind of you know where I'm going, everything is a neighborhood character finding always, right? Especially in a variance, particularly in a variance.
Right.
So we want this to be a contribution to the neighborhood, not somebody saying, oh no, look what's going up, oh my God, what's happening to the neighborhood. Right? Okay, good. Okay, are there any speakers on this item? Okay, so you need to,
If we could submit 2 weeks after the New Year's, that'll give us time to do the area study that you need.
great. Okay, so then the 13th of January, is that
Thank
it?
you. Yes,
Okay.
that's great.
For a hearing on the 27th.
Thank you very much. Thank you for your time
Thank
today.
you.
Thank you.
Item number 2, 32913BZ, 145 Girard Street, Brooklyn.
Okay, this one, I think the applicant's not here, but they asked to adjourn. Supposedly, they were going to make a submission today. I don't know whether they have. So far, not. So 1:30, I don't really know. Maybe we should push this off a little bit more, right? Okay. So how about we have them submit on the 25th? Think that's doable? Yeah, okay. 25th for a hearing on the 9th. We have room on the 9th, I think. Yeah, I think. Okay, 25th and 9th.
Item number 3, 9414 BZ, 1150 East 22nd Street, Brooklyn.
Good afternoon. Dennis Delangelo, representing the owner. We were aware of some of the comments that were made at the review session. If I may, I'd like to address some of them. And the issue of the Sanborn map and the legality of the one-story enlargement in the back. When I measured up the building, I looked at the outside, the inside, it looked like it was part of the original structure. Apparently, checking the records at the building department, the current Sanborn map in the borough shows the extension, but there's no way to know when it was put on. We've come to the conclusion then that it's an illegal or an undocumented construction. The question comes up then of how do we treat the perimeter walls? On drawing E6, we're including that extension as the perimeter walls. We have other jobs in the pipeline. If the board would like to make a decision on this, whether we should make a distinction between undocumented construction and lawful construction and include only the lawful construction as perimeter walls in the calculations, that could be done with no problem.
Well, what if have you looked at a Sanborn map, say, from 1958 or a number like that? Maybe
They
it would
only
show
have
up.
the original and the current. The current has paste overs. So
I see. You don't have anything in between. Not even in the library, or?
I'm sure they're available, but the All of Archives has the one we submitted, I think it's 1929.
Because normally the public library has Sanborn maps that go, that retain the sequential changes. Can you take a
Yeah.
look? That would make it easier. Then we could say it's pre-61 condition, therefore.
Well, the issue is also that the building department has absolutely no records of anything filed on this site since it was constructed. So we have to make the assumption then that even if it was constructed prior to 61, it's undocumented.
I see.
So we
Okay.
would look at it that way.
I can't answer this question right now, so maybe we get back to you on that one, on how to treat that, unless you have a proposal.
I would tend to perhaps agree with Mr. Delangelo that because it is undocumented, which is a good way of putting it, that one should only consider what can be documented legally, and that if you were looking at wall height, you might want to look to what you could prove at the building department was actually built
Sure.
on the site. That would just be my interpretation of the problem and how I would handle it.
All right, maybe what I can do is I can definitely show that on the drawings. I'm sure we can identify an undocumented portion and a lawful portion, and we would then include the lawful portions in the perimeter walls. Also, I would change the analysis. There is a section, legal and existing, will indicate under the legal what we assume it should be, and under the existing, and that would be in the record then. The existing would be the 24 feet, and the legal would be whatever it turns out to be.
Right.
Good. Yeah, we can make the correction to the drawings, to the zoning analysis. There was also an issue of the porches and the terraces and the garage. We do have a note for the terrace in the front and a note for the garage in the back. We do not have a note that the porch in the rear is also subject to the DOB approval. We can indicate that.
Well, actually, so that one was more, we're aware that the garage and the porch are subject to DOB approval. It has more to do with the fact that you're proposing to reduce the rear yard very significantly, and then in addition to, once you've reduced it to 20 feet, which is already a big reduction, then you're proposing to essentially fill it up with stuff. So my question is, how can you really, then what's left of your rear yard? You've essentially left a little tiny area for, I don't know what, to stand the barbecue and stand up while you're eating. I'm not really, my problem with these applications where they sort of encroach on all the open space in all directions and then put the garage in too, and then there's a terrace or a balcony on top of that, And so until there isn't anything left in the way of open space, and I'm not understanding the reasoning for that, and I also view it as a negative impact on adjoining property. So that's what I was getting at, that it should actually be removed. I see your neighbors don't seem to have a garage at the rear, and unless that's what the attachment is, because one of them is a one-story extension at the rear, maybe that's the garage.
I think it used to be a garage, possibly.
But so they don't have garages, so they've already reduced their rear yards to 20 feet. So, but those are only one-story extensions. So a lot of the discussion about these special permits revolve around what is neighborhood character at the rear? What are you doing to the donut, effectively, by extending reducing the rear yard experience and filling it up with stuff? Because the original garage at this site was much smaller,
Yes.
right? So,
I believe that, well, this is an issue with not just Brooklyn. The zoning allows us to put it's a permitted obstruction to have the garage in the rear yard. Also, the garage will eventually count as open space. It's allowed to encroach into the open space.
right.
So while it is a structure, the zoning is looking on it as open space. It was our intention to use the roof of the garage as an open area, an open deck. We were going to put a flat roof on the garage.
How do you get into it?
But we're not submitting plans of that at this point. That would go through the Department of Buildings. The construction that we're showing of the garage would be as of right, with or without the special permit. And I think the building to the north also has an enlargement to the main building, which comes back almost to the point that we're discussing.
To the north.
We could show the garage in reality instead of in phantom lines as far as what we're proposing to the building department, as far as the roof, the flat roof, the fact that it would be recreational area.
Well, I think from my perspective, the issue is make your case for how what you're proposing to do to the rear yard is not having a negative impact on on the neighbors, on neighborhood character, effectively, from the rear yard perspective. I mean, we always talk about the rear donut, the 60-foot donut. The special permit is having the effect of reducing that down to a 40-foot donut. What is that doing to the neighbors who are not, say, participating in this? These others have these 1-foot structures, which are probably former garages, therefore would have been permitted obstructions. Whereas you're not proposing a permitted obstruction in your rear, aren't you also encroaching on your rear yard? Yeah. So you're not proposing a permitted obstruction in your rear yard in terms of the house. You're actually decreasing even more the rear yard, right? So in addition to that, you want to fill it up with a garage. So it's different when you're reducing it from two different directions and you're putting in a much bigger garage. And then you're adding the balcony. And so you need to really make a case for why that kind of imposition on this rear yard won't negatively impact the neighbors. Photographs from the backyard, from the roof of your building, looking at those would help.
Okay, maybe we could also look at some other garages in the neighborhood.
Yeah, on this block specifically.
Sure.
In this donut. I mean, these may be one-story garages that are really tall. I mean, I don't know. I just don't know.
Not anymore, yeah.
Not anymore.
Now we're limited to 10 feet.
Okay.
So shall I, as far as the perimeter walls, the undocumented, that's something that we can definitely go forward on?
Yeah, you should do it as recommended, yeah.
Okay. And
Okay, what else?
Streetscape.
Yeah.
the streetscape of the photos.
Comment that you needed a wider streetscape. Because you just have two adjacent buildings and it looks significantly higher, so.
Oh,
If you
you
could
want, on
widen-
the streetscape drawing itself, you want us to include the next buildings?
Well, whatever works to show that this building fits into the neighborhood character. it might, require additional buildings, or, if you look at both sides of the street.
Well, and also, I think you're not familiar with some of the requests that we've been making for other applications, basically since I started. So I'm trying to understand the neighborhood context, so what we've been doing is asking for streetscape studies that look like this, where there is basically, well, this is the way this person does it. I actually prefer panorama if you have the skills, but this one actually just sort of lines them up next to each other. And the ideal is to do a photo montage inserting your building into that. That all depends on skills. You do these gorgeous drawings, so I'm thinking. that
You want the
could do
whole
that.
block, or?
Yeah, so the idea is to get the block character with the photos, as opposed to necessarily having to draw each one of these houses. And then if you could just render in, I'm assuming this is in your skill set because your drawings are so beautiful, that you render in your house into this, and then we get a better sense of the scale relative to the neighbors.
Yeah, we can get an approximate height
Yeah,
of
exactly.
the buildings.
Right, okay, and then, so, yeah, and that was another thing, this kind of ongoing discussion about how you read on the drawings, which portion of the house is remaining.
Yes.
Just to make that very clear, because of course, this is required to be an enlargement of an existing house, so it should be clear. I saw dimension lines, but then the, sort of the legend doesn't, it explains either or black or clear, and it's a wall that has both, so it looks like you're doubling up your wall, and that's,
Yeah, I think part of the problem is that we have windows where the transition happens. So I guess we can show, we'll find a way of doing it.
okay. Just to
Yes,
make that
we'll make it
clear.
more clear.
And then, my only comments about the massing were, it's generally quite an attractive design. It's just that it's reading a little bit massive, and just if there's a way to keep in touch with what's going on in the adjacent properties. That's why we need the streetscape, because your immediate neighbors aren't necessarily where you draw from. You can be drawing from heights and massing on the rest of the block. And it seems to be about the same height and elevation as your neighbor to the, whichever way that is,
North,
1144. But when you look at it in the side elevation is still reading kind of large. So if you could look at that against the neighbors.
I think
Okay.
problems that we're beginning to see with the special permits is that we're not requesting any waiver of the height regulations.
Right.
So all of these buildings are within the as-of-right height and setback regulations. But up until now, because of the bulk regulations, there was really no way that these buildings without a special permit could get to that bulk, to actually get to that envelope.
Right.
Now with the special permit, we can actually use that envelope as a control. Where before it was just
Concept.
yes. Now it's a
Right.
reality, and
Right.
obviously we're building to that line to give our clients the bulk that they seem to want.
It's not so much about floor area in this case, it's really about the mass, and just to not be overwhelming neighbors. And again, because we haven't seen who all your neighbors are, maybe it's in line with it, but we didn't provide enough information to show that.
Okay.
Okay? I'm mostly talking about the side elevation, really.
Sure. We'll see if there's comparable structures.
And then I think Commissioner Hinkson, you had a comment about the foundation?
Well, I think he answered my question. It appeared that you are sort of double walling the
Right.
foundation, and I'm assuming because you're breaking through in your original foundation with sort of like with windows, then you probably need to back up in some way your foundation wall because you're taking out some of the mass. Is that what I'm reading? Is that why there's a double line?
Yes, we had originally gone to the extremity of the undocumented portion, which is a crawl space. Then we brought it back And it was a question of treating that as the perimeter wall again in the cellar. It's the perimeter wall of the cellar, but upstairs it's not. This is the clarification that I think we'll make on the next set of plans.
Okay.
That will actually identify undocumented construction, legal, and this will let the
I see
perimeter
what you mean.
walls
Yeah,
make more
yeah,
sense.
yeah. Okay, yeah, that,
Yeah, we didn't do that on the first floor. We used the perimeter walls of the undocumented portion.
gotcha.
Okay.
All right, we'll see how that looks then.
Yeah, there really is no perimeter wall existing where the building used to be on the first floor. But we'll indicate that as legal construction, trying to identify it.
Okay.
Okay. Any other comments? No? Are there any speakers on this item? I think not. Okay, so how much time do you need to do this?
Might take a while with the streetscape. Everything else, we can probably get back to you next week, but the streetscape might take maybe 2 or 3 weeks.
Okay, so do you want to, our last hearing is December 15th. Do you want to submit, sorry, I'm on the wrong year. December 16th. Do you want to submit in time to be heard in December, or is?
Yes, I think we can do that.
So can you submit, well, how about this? You submit in 2 parts? Would that work for you?
Well, it would probably work better for the board if we brought everything in
Yeah, so.
one shot, yeah.
Because we need to see it 2 weeks before, that's why I'm thinking it's
Sure.
not enough time for you. So December 2nd?
Yeah,
Might not be
well-
enough? Okay, December 2nd submission for the hearing on the 16th.
Great, thank you very much.
Thank you very much.
Item number 4, 11914BZ, 1151 Third Avenue, Manhattan. This is for the second and third floor.
Good afternoon. Jay Goldstein for the applicant.
Okay, so I don't think we had any comments on this. So are there any speakers on this item? So for a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. For a decision on the 16th.
Item number 5, 12014BZ, 1151 Third Avenue, Manhattan. This is for the fifth floor of the building.
Jay Goldstein for the applicant.
Same building, other floor, and no speakers on this item because of the same 3 people who didn't have a comment on the last item. And so for a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. And with a decision on the 9th, 12/9.
16th?
The last one
I'm
was
sorry,
16.
16.
16.
How did that happen?
I'll take the 9th
Yeah,
if it's
yeah,
available.
sorry. I thought I made the correction
get
on
greedy.
all of them, but I didn't. Okay.
Okay. Item number 6, 12114BZ, 1151 Third Avenue, Manhattan. This is for the fourth floor.
Good afternoon. Jay Goldstein again for the applicants.
Any speakers on this item who just appeared? No. For a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. For a decision on 12/16.
Thank you very much.
Item number 7, 15114BZ, 19 West 21st Street, Manhattan.
Good afternoon, Madam Chair, Commissioners, Frederick A. Becker. I'm batting cleanup again.
There you go. So this is for a very exciting application for a one-room yoga studio, Fred.
Very small, very quiet.
Are there any speakers on this item? No comments? For a motion to close, then? Oops, sorry.
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. For a decision on the 16th.
Thank you very much.
This concludes the November 18th public hearing of the Board of Standards and Appeals.